All right, good morning, ladies and gentlemen. My name is Judge Law, and we're going to begin with our state all-purpose calendar today for January, I've forgotten the date, January 15th, 2026. And let's see, I'm still waiting for, is courtroom two here? Okay, I see an individual at the Coney. Okay, good morning, sir. How are you?
Good, how are you?
Fine, thank you. Is that everyone? Are we bringing in more folks later on?
I probably have some more folks, not many
Okay.
more folks, but about a few more
Uh,
people.
all right. Well, I'll just begin with who we have right now. Good morning. My name is Judge Law, and we're going to be addressing the misdemeanor cases that have already been accused with the State Court of Fulton County. And today is essentially going to be what we call a plea and arraignment calendar, or we may also address other matters such as bench warrants and probation matters, as well as motions to modify any bonds. By the meantime, when we address each of your cases, please keep in mind that if you are charged with one or more misdemeanor offenses, you have a right to remain silent. Anything that you choose to say during the course of this virtual proceeding, your statements can and will be used against you in the treatment of your case. Keep in mind that these proceedings are being recorded as well as a live stream. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. And shoot, I thought I gotten, I guess it didn't print out. Okay.
You missing something, Judge?
Miss Tucker's
Announcements?
announcements. Yeah, I thought I had printed out, but I guess I didn't. But that's okay. I've got it on my email.
Okay.
Okay.
Did you get the probation calendar?
Yes, I did. It's two cases, right? Or one individual, two. No, it's one case.
That's correct.
Okay. There's no DV bench warrant, right?
Yes, there is.
Oh, there is.
Mhm.
Okay, I will print that up too.
It's just one case, Judge.
Okay.
Good morning, by the way.
Good morning, good morning. All right. Let's see now. I have Mr. Scirocco. Do I have a PD or a defense counsel? I have someone at Oconee County Jail. Would anybody be able to tell me who that is? No?
Your Honor, it's going to be David Horst.
Oh, Mr. Horst with the probation matter. Okay. And is our probation officer on Zoom? All right. Good morning. All right. And officer, I'm sorry, I'm senior moment. I'm forgetting last names. May I have your last name?
Alan.
Alan. Okay. All right. And who represents Mr. David John Horst, Horst?
Judge, actually, at this point, I mean, we'll represent him, but we don't have an offer from JCS or don't know anything. We just got this calendar yesterday, so.
All right, let's see if we can proceed and see what's going on. Miss Allen, was there a recommendation by probation for Mr. Horst that Mr. White can discuss with Mr. Horst?
Your Honor, I actually was going to defer to the court. He has to complete domestic violence classes. It is 213 days remaining on his case. And Your Honor, the domestic violence program is 6 months. And also, I just checked his Fulton County booking sheet, and he has a hold out of Birmingham, Alabama. So I'm not sure how long he's going to be in Birmingham. So at this time, I will have to, unfortunately, I have to defer to the court to make a decision.
Mr. White, would you like a moment to speak with Mr. Horst?
Certainly, I'm not sure exactly what I'm going to be able to relate to him, but yes, if we just do a breakout and I'll talk to him briefly.
All right. Ms. Champion, could you please place Tom White and Oconee County Jail in breakout? Is there a deputy seated at the computer at Oconee County Jail?
Yes, Your Honor.
All right, sir, you're going to see a message on your screen. to join a breakout room with Mr. Tom White. Thank you.
You're welcome.
And is that Miss Tucker in courtroom 2? Yeah, all right, she's there. All right, excellent. Miss Tucker, are we ready to proceed? And Mr. Bartell too. Good morning. Okay. All right.
CBC cases.
All right, sir. Courtroom 2, who shall we begin with? Preferably someone represented by Miss Tucker or Mr. Bartell?
And number 43 through 45, Mr. Parks. Parks, your name Parks? Yes. Atlantic Parks, sir.
All right, this is Darius Parks. Mr. Parks is positions 43, 44, and 45.
And position 45, it just got duplicated on the calendar. It's the same as 44.
Okay, so I'm just going to cross out position 45. All right. So Darius Parks has got 2 matters before the court. It is case 26 CR 031D, in which he is accused of criminal trespass, public drunk, and a PI charge. And he's got a second case, 25 CR 6861D, for criminal trespass. The first case is from a January 1st, 2026 incident. The second case is from a January 2nd, 2026 incident. Mr. Parks, you've been advised of your rights, and your attorney is Ms. Tucker. Ms. Tucker, is this going to be a, well, how are we going to proceed?
It'll be a negotiated plea, Your Honor.
All right, thank you. Mr. Parks, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? I can't hear you. Was that a yes or no?
Yeah.
All right, you'll need to speak up. I think the mic may be a little further away from you. Okay, Mr. Scirocco, what is the recommendation for both these cases?
Yes, Your Honor. For position 43 on criminal trespass, public drunk, and the PI, which are counts 1 through 3 respectively. On count 1, 12 months probation concurrent with count 3. Stay away from all MARTA premises and property. Count 2, 12 months probation concurrent with count 3, ADET. Count 3, 12 months, served 28 days, credit for time served, balance probated. SDET, as well as 60 hours community service. And as for position 44, the criminal trespass, 12 months probation concurrent with position 43. Stay away from Azalea Fresh Market at 25 Peachtree Street, Northwest in Atlanta. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. That is all for the state. We are fine with non-reporting upon completion of the terms.
Your Honor, we do so stipulate for the purpose of the plea, and we would also request non-reporting once he completes all the terms.
Oh, let me see. Do I have a pretrial officer on Zoom, please? Ms. Stallworth? Or?
Yes, Your Honor. Give me just one moment. I'm sorry.
No problem. I just wanted to know how many cycles Mr. Darius Parks has. I see that other than these 2 cases, his last booking at Fulton County was 2014. Does he have any other matters in other jurisdictions?
There are 16 cycles in total. As far as convictions, there's a 2010 out of Fulton. You just want to know out of Fulton?
Okay. Does he have any probation matters recently in the last 5 years?
No, Your Honor.
Okay.
Not in the last
Yeah.
5 years, though.
Okay. Yes, Ms. Tucker, I will accept non-reporting once he has completed all the programs that he's required to do, and his probation fees are up to date, and he hasn't been arrested while on probation.
And
Thank you, Your Honor.
Okay. Mr. Parks, have you consumed any medicine or alcohol recently?
no.
And have you understood what's going on in both your cases?
But Kelly said that.
Yes.
And are you satisfied with your attorney?
Yes.
And has your attorney explained to you that if you plead guilty to these charges, you'll be required to report to probation every month and complete the conditions that are required?
Yes.
All right. And has she also explained that if you enter this plea, you would have, can you hear me all right?
Yes.
Okay. If you enter this plea, you would have to give up your right to a trial in a court of law. You will not be able to go back to face a judge or a jury with respect to these cases. You won't be able to confront your accuser, challenge the evidence brought against you, present your defenses and arguments, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights? Are you prepared to give up these rights?
Yes.
How do you plead to criminal trespass at the Azalea Fresh Market on October 31st, 2025?
Guilty.
How do you plead to criminal trespass, public drunk, and a PI charge from a January 1st, 2026 incident?
Guilty.
For position 43, count 1, criminal trespass, the sentence is going to be 12 months to serve 28 days, credit for time served 14 days, to stay away from all MARTA property in accordance with any and all active suspensions. That includes the stations, the buses, and the trains. For the public drunk charge, that's going to be 12 months concurrent with count 3, and he'll be required to undergo an alcohol and drug evaluation and submit to any treatment that's required. And this must be done within the first 30 days of being released. With regards to the PI charge, it's going to be 12 months to serve 28 days, credit for time served 14 days, balance probated. He will report to probation on Monday before 3 p.m. And within 90 days of being on probation, he will enroll in an SD program and submit to all evaluation and treatment that's required. He will also complete 60 hours of voluntary community service at any nonprofit agency, and it cannot be a church and it cannot be a school. And he must complete his community service at a minimum rate of 10 hours per month, beginning with the first month. With regards to the second case, this will be a concurrent sentence, and it's 12 months to serve 28 days, credit for time served 14 days, to stay 200 yards away from the Azalea Fresh Market at 25 Peachtree Street in Northwest Atlanta. He will report to probation every month, be current with his probation fees, and once he has completed all the programs, the community service, and he has not committed any violations of probation and is current with his probation fees, then and only then will his probation be non-reporting. Thank you.
Thank you.
Before we proceed to the next matter, could I just inquire, who is the conflict attorney for Antonio McGee? Do we know?
Well,
Sorry, I missed that.
No, we do not have one. I sent it out to Mrs. McLeod and Mr. Murphy, and they have not answered back to me yet. So I'm trying to, when they get on the line, maybe we'll be able to ask who can assist us.
Okay, thank you.
All right. With regards to the probation matter, Mr. White, are we ready to proceed?
We are, Judge.
Okay. This is David John Horst, convicted of battery family violence in case number 23 CR 0037768. He's got a probation violation case where a warrant was issued, and this is from June 13th, 2025, case number 26 PV 039. Officer Allen with the probation office, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. And what was the reason a warrant was issued?
Your Honor, the defendant failed to report to our office. He's failed to complete the 40 hours of community service as well as the family violence program. Your Honor, it looks like he's reported at least 2 times to probation, where he was given the information to enroll into the domestic violence program. And at some point, Your Honor, he did stop reporting to probation. It is 213 days remaining on his case. He has now been in custody since December 16th of 2025. And again, Your Honor, I did notice that he has a hold out of Birmingham, Alabama.
All right, and what's this, and the state is, excuse me, the probation is deferring to the court.
Your Honor, because of the time frame remaining on his case, he will be somewhat shy of maybe 1 or 2 weeks of the program. But if he's going to be transferred to Birmingham, unfortunately, he would not have enough time to complete that 24 weeks of domestic violence.
Okay,
I can address that, Judge.
all right, Mr. White?
Actually, Mr. Horst has already completed 22 of the classes, so that's not going to be an issue. Additionally, we don't expect any, there's a high likelihood that he won't be going to Alabama. He is out on bond on a case there. It is pre-conviction, obviously, and he does have a private attorney that's working on that. And he's been informed by that attorney that the extradition matter is corrected and he should not be going to Alabama. Obviously, I cannot guarantee the court that. But the fact that he's already completed 22 classes, he was reporting. He did go out of state for work. He did try to report by phone, but was unable, was unsuccessful in that, obviously. We're just asking that you reinstate him on probation and allow him to complete the final 2 classes in his community service. Plus, he's been in jail a month now, Judge.
Has his probation ever been amended to allow telephonic reporting?
No, Your Honor. And also, I will add, as far as the domestic violence, although he's completed 22 of the 24 programs, Your Honor, because of the state requirements, he will have to start over. He's not going to be able to continue on and complete those 2 classes.
He's completed those 22 classes while being incarcerated, so he is on course to finish.
Which school did he go? Or which school did he do the program?
I'm not aware.
May
Judge.
I have the name of the school?
Oh, okay.
Does your client know the name of the school?
He's been doing it while incarcerated.
Understood. So he has to sign up somewhere on a website to do the classes. What's the name of the website of the school?
Path of Education. It's here. It's offered into the tablets that we have. I've been using my time here to do those courses. So when I sign in and log in with my ID number and all that, that's where I found all that stuff.
And how many classes did you complete while you were at the Coney County Jail?
There's over 100, there's hundreds of them, but I focused on the self-awareness and the domestic violence and a little bit of the substance abuse, anger management. I tried to focus on those.
Okay, so this is not a formal DBIP program where it's consistently 24 weeks where you attend every class once a week. So it's not a program that you've enrolled in. You just pick a class and do it.
Yes, ma'am.
Okay.
And Judge, you don't have to attend those classes in person anymore. You can do them online.
That I do know, Mr. White, and I also know how DBIP works.
And my point is that it's not necessarily weekly. He can, if the class is being offered in his next stage, he could conceivably do that in a couple of months.
Let me get one thing clear with everyone. When an individual is sentenced or ordered to do a domestic violence program, that means enrolling in a formal domestic violence accredited program. And it also requires the individual to report to probation in person unless otherwise ordered. Now, I'm not about to engage in piecemeal sentencing where the defendant gets to choose how they want to carry out their sentence. So, Mr. White, I understand the substantial compliance argument, but I'm not about to allow an individual to do his probation based upon what he thinks is best for him, or what is more accommodating for him.
That's not what we're asking, Judge.
That's precisely what you're asking. You're telling me to accept his ability to sign up for classes, whichever that's available at the jail, because he thinks that complies with his DBIP probation condition.
Judge, that was not my point at all. My point was that he is taking active measures, still has plenty of time to complete the course.
No, he doesn't. He has 213 days, and he still has to report to Alabama. There is absolutely no indication that he has been excused from the Alabama case. And I understand your frustration, Mr. White, because you've only had a brief conference with him. But what I do have before me is an individual who did not report who chose to report by
He-
telephone. That's absolutely no evidence.
He did report for the first he says for the first 3 months,
Well, hallelujah.
2 months. Judge,
I am
we're
going
not-
to, go ahead, sir. Anything else before I rule?
Judge, we're not arguing that he was properly complying with probation. But we do have this all the time where he was making more of an effort than most and has tried in the last month to get caught up. There is plenty of time, even if, as I was saying, on the DVIP, if he does that online, he could probably complete that within a couple of months, because you don't have to go once a week. There are different levels going on all the time, and as long as he is compliant, he could complete that within a couple of months. Additionally,
What
I
is the
did-
case holding him in Alabama? Is it a misdemeanor, a felony?
it is a felony.
Was it acquired during his probation term?
As I said before, Judge, he's been out for 2.5 years on probation on that case. I mean, on bond of that case. So that case has been open for about 2.5 years.
Officer Allen, when was he convicted of this battery DV case?
Your Honor, he was sentenced on January 15th of 2025.
All right, thank you. Anything else, Mr. White?
No, Judge.
Thank you. I have very little faith in the fact that Mr. Horst will be able to comply with the strict conditions of his probation. I'm going to revoke the remainder time of his probation, give him credit for time served. And once he has completed the remainder time, where the Fulton County Sheriff will give him 2 for 1, then he may be released to Alabama because he has a fugitive hold from Alabama. And once he's completed his obligations here by completing his jail time, then he will go to Alabama and complete whatever obligations he has in Alabama. Thank you.
Your Honor, that concludes my business. May I be excused?
Yes.
Thank you.
Courtroom 2, who do we have, please?
Number
That's-
40, Porter Hernandez. Porter Hernandez.
And what,
Your
Mr.
Honor,
Hernandez?
I'd like to break,
46.
Your Honor,
Well, hang on. I'm getting a break in the audio. Okay. Yes, Mr. White, what would you like to say?
I'd like a breakout room with Mr.
With-
Horst, explain to him what just happened.
I think Oconee just signed off.
Brilliant.
Okay. Courtroom 2,
46.
46. Is this Tyreek Portier Hernandez?
Yes, ma'am.
Thank
Good morning.
you. Good morning. Mr. Portier Hernandez, his case number is 26CR004D. He's got a PI charge from December 31st, 2025. Mr. Hernandez, you've been advised of your rights, and your attorney is going to be Ms. Tucker. Ms. Tucker, is this going to be a negotiated plea?
Yes, Your Honor.
Okay. Mr. Portier Hernandez, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Scirocco, what's the recommendation?
Yes, Your Honor. For this charge, the state's recommendation is 12 months, served 30 days, credit for time served, balance probated, SDET and BHET, no further contact with a Miss Sarah Moore, stay away from all MARTA premises and property, and 40 hours community service. And we are recommending stay away from all MARTA premises and property, irrespective of any current suspensions. If we could sound for Miss Moore when appropriate, and we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. In addition, we would object to non-reporting here.
Sarah Moore, if you're on Zoom, this is the time to unmute and start your video. All right. Ms. Tucker, yes, ma'am.
We do so stipulate for the purpose of the plea, Your Honor.
Okay. Mr. Poitier Hernandez, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am, I do.
Are you satisfied with your attorney?
Yes, ma'am, I am.
Are you a resident of Atlanta?
Yes, ma'am, I am.
And do you have a verifiable address?
Yes, ma'am.
Have you provided the address to your attorney?
Yes, ma'am.
Where is this? Which city is the address in?
It's in Fairburn.
Okay. Mr. Poitier Hernandez, has your attorney explained to you that if you accept this plea offer, you would have to give up your right to a trial in front of a judge or a jury. You would have to, you will not be able to confront your accuser, challenge the evidence brought against you, be able to present your legal arguments and defenses through counsel, and the state won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, she explained to me, yes.
I'm sorry, I didn't understand the response.
Say yes, my attorney explained it to me.
Okay, and are you prepared to give up these rights that I've explained to you and that your attorney has explained to you?
Yes, ma'am.
How do you plead to one count of PI from December 31st, 2025?
I plead guilty.
Your sentence is going to be 12 months to serve 30 days. Credit for time served. Once you have completed your jail time, you'll be required to report to Fulton County Probation within 48 hours.
Okay, thank you.
No, I'm not done. I was wondering if you're paying attention.
Yes, yes, I am.
When do you report to probation?
Monday.
Monday before 3 p.m.
Yes,
While
ma'am.
you are on probation, you will report every month, and you're to stay away from all MARTA property in accordance with any active suspension. You are to have no contact with Sarah Moore. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. Within 90 days of being on probation, you will enroll and complete an SD evaluation and submit to all treatment that's required. Within 30 days of being on probation, you will submit to a behavioral health evaluation and submit to all treatment that's required. You must be compliant with all treatment and medication as indicated by the evaluators. You are to also complete 40 hours of voluntary community service, and that must be with any nonprofit agency that's not a school and not a church. You will maintain a regular address with the court and with probation, and you will report every month. Thank you.
Thank you.
So that's right. I'm going to number one, Mr. Ashley.
Right, Mr. Ashley is represented by Mr. White, and this is going to be a plea hearing rather. This is Jericho Markeith Ashley, accused of criminal trespass and possession and use of a drug-related object from 25 CR 8532Y. Mr. Ashley, you've been advised of your rights. Your attorney is Mr. Tom White, and may I place you under oath for the plea? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
No.
Mr. Scaraco?
Thank you, Judge. With respect to the criminal trespass count one, the state's recommendation is 12 months served, 36 days, credit for time served, balance probated, MHET, stay away from 875 Cruz Street in Atlanta. That's an apartment complex, and 30 hours community service. As for count two, the possession and use of drug-related objects, the state's recommendation is 12 months probation concurrent with count 1, undergo an ADET. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Mr. White, do you so stipulate, and does your client accept the terms?
Yes, Judge. We do stipulate for the purposes of the plea, and he has accepted the terms. We would just ask the probation to terminate or go non-reporting once he completes all of his requirements.
I do see 4 probation violations from 2013 to 2018. So we would object to non-reporting or termination.
Mr. Ashley will be required to report for a minimum period of 6 months if he has completed all the conditions and is up to date with his probation fees. Then I will allow probation to be non-reporting. Mr. Ashley, did you understand the court's ruling on your probation reporting requirements?
Yes, ma'am.
All right. Mr. Ashley, have you consumed any medicine or alcohol?
I have lately, but
Did you consume any medicine recently?
I mean, I have, but they had to do a little work to some of it. Due to one of my appointments that I had missed out on, but I had gotten into a little trouble at Ten Park Place. They had changed it up a little bit, and I had missed out on.
Did you consume any medicine while you were at the jail?
Yeah. I have.
Okay. Are you still able to understand what's going on in your case today?
Yeah, I do.
Do you understand what your attorney has said to you?
Yeah.
And are you satisfied with your attorney services?
Very.
I'm sorry, was that a yes or no?
I said very, yes.
And if you decide to accept this plea offer, you would have to give up your right to a trial in front of a judge or a jury. You will not be able to go out to a courtroom to face them, to be able to confront your accuser, to be able to challenge the evidence brought against you, present your own legal arguments and defenses through an attorney, and also the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Why would I have an accuser?
Well, if you decide to plead guilty today, and if you do it freely, knowingly, and voluntarily, the knowing part means that you understand that you are pleading guilty and you're going to be convicted and sentenced, and you won't have an opportunity to go back to a courtroom and challenge these criminal charges against you. If you decide to challenge them, then you will have an attorney to help you go to a courtroom and challenge it in front of a judge and a jury.
It's still good. Like, I'm gonna go ahead and plead guilty to it and take up the terms on what you were saying.
So I'm going to ask you again, are you prepared to give up the rights that I've just outlined?
Yeah. I get it up and plead no to that.
How do you plead to criminal trespass at the apartment complex at 875 Cruz Street?
I'm guilty. I stayed up.
How do you plead to possession and use of drug-related objects?
Guilty too.
Your sentence for criminal trespass is going to be 12 months to serve 36 days, credit for time served 18 days, balance probated. This coming Monday, you will report to probation before 3 p.m. at 132 Mitchell Street. While you are there, you will complete 30 hours of voluntary community service at a minimum rate of 5 hours per month. And that must be done with any nonprofit agency. It cannot be a church and it cannot be a school, but it can be another nonprofit agency like Goodwill or Salvation Army. You're also to stay 200 yards away from the entire apartment complex at 875 Cruz Street in Atlanta, Georgia. Within 30 days of being released, you will undergo a MH evaluation and submit to all treatment and medication, and you'll be compliant with all treatment and medication. For the drug-related object charge, it's 12 months concurrent with count 1, and you will undergo an alcohol and drug evaluation and submit to any treatment that's required. This must be done within 30 days of being on probation.
All right.
You are not to consume any illegal drugs. You're not to consume any alcoholic beverages, and you're not allowed to own or possess any firearms. If you complete all your conditions and you are up to date with your probation fees, then your probation will be non-reporting, but this will be only after you have been on probation for a minimum period of 6 months. Thank you.
All right, next, we got 28, Mr. Harris.
Jeremy Harris is accused of criminal trespass causing damage to property, case 26 CR 058A. Mr. Harris, you've been advised of your rights. Your attorney is Mr. White. I understand this is going to be a plea. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank
Yes,
you.
ma'am.
Thank you, sir. Mr. Scirocco?
Yes, Judge. On the criminal trespass and damage to property, the state's recommendation is 12 months, served 45 days, balance probated, and credit for time served. BHET, stay away from 361 Far Road, Northeast in Atlanta. No further contact with Miss Brandy Anara Ann Gilbert, and restitution to Miss Anara Ann Gilbert in the amount of $100. We would ask that the court sound for the victim when appropriate, and we would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea.
Guilty.
Miss Brandy Anara Engelbert, if you're on Zoom, this is the time to unmute and start your video. This person, Zoom user, what's your name?
Tariq Dargan. I'm at the courthouse. They told me to be here today at 9 o'clock, but I just came down to the clerk office and they gave me the meeting.
Okay, please
ID number.
tell me your name again.
Tariq Dargan, senior.
Okay, Mr. Darden, please mute your screen and switch off your video until you hear your name called. Thank you. All right, Miss Brandy has not responded. Mr. White, does your client accept the terms and do you so stipulate?
Yes, Your Honor, we do stipulate for the purposes of the plea, and we are still asking to enter this as a plea. We would ask for 2 months of fee waiver so that he can apply that to the restitution, and then ask that his probation terminate or non-reporting once it completes all those requirements.
We would not object to non-reporting here upon completion, Judge.
Okay. Once he has completed all the conditions of probation and he's up to date with his probation fees and has paid off the restitution, then his probation may be non-reporting. Mr. Harris, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to confront your accuser, face a judge or a jury, be able to present your own defenses and arguments, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass causing damage to property?
Guilty.
Your sentence is 12 months to serve 45 days, credit for time served. Once you've completed your jail time, you will report to probation within 48 hours. While on probation, you will stay away from the entire apartment complex at 361 Far Road in Northeast Atlanta, Georgia. You're also to have no contact with Brandy Anara Engelbert. You're also required to complete a behavioral health evaluation and submit to treatment that's required. This must be done within 30 days, or at least get an appointment within 30 days of being on probation. There is also a restitution of $100. You will start paying your restitution for the damages cost at a minimum rate of $10 per month. And this payment will be paid, but you make the payment to your probation officer, who will then remit the funds to the victim. Like I said, once you've completed all the conditions, you're up to date with your probation fees and have completed restitution, then your probation may be non-reporting. But until then, you will report to probation every month. The first 2 months of your probation fees will be waived. Thank you.
Shut the fire off. All right, go to number 34, Mr. McGee.
And this is the one I was inquiring about for either Mr. Murphy or Ms. McLeod.
I'm sorry. Who do we have again?
34, Mr. McGee.
Okay. Do we have Mr. Murphy?
Morning, Judge.
Good morning. This is Antonio McGee. He's accused of 2 counts of battery family violence. This is from an August 1st, 2025 incident and appears, let me just check on a couple things. First of all, Mr. McGee has not been appointed counsel at the present time. Would that be correct, Ms. Lewis?
That is correct, Judge.
All right. Mr. Murphy, would you have any objection to being appointed as counsel for Mr. Antonio McGee?
No objection, Judge.
All right. So, Mr. McGee, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. I'm going to appoint Attorney Dennis Murphy. His name is on the screen as ATTY, Attorney Murphy, and he will be representing you for the present time. Mr. Scirocco, there's been a request to transfer this case to the Superior Court as a felony matter. What is the status of that request?
Judge, so this is actually unique. I have withdrawn that. The state is actually has an offer for Mr. McGee. So I wanted to know who to send that to, but I can send that to Mr. Murphy now.
Okay.
And yes, there is a prior conviction. It was just after the incident date here, Your Honor.
All right. All right, Mr. Scirocco, if you can either email or put the state's offer directly to Mr. Dennis Murphy through the chat feature. And Deputy, we're going to address Mr. McGee's case later on this morning after Mr. Murphy has had an opportunity to review the offer and call the jail to speak with him.
Okay.
Thank you.
I'll go to 8 and 9, Mr. Kane.
Mr. J. Montez Kane is got 2 cases before the court. One is for battery and criminal trespass under 25 CR 573E. And Mr. Dennis Murphy, if you are still free, may I also appoint this case to you? He's got this case and he's also got a bench warrant.
Judge, we have that's already been appointed to Ms. McLeod.
Oh, he has? I don't have that on.
That's
on
my
the-
information.
That's correct. Ms. McLeod is the.
Oh, okay. Sorry about that. Oh, that's okay. There's the name. And is Maureen McLeod on Zoom? All right. Miss Deputy, we cannot address Mr. Kane until his attorney appears. His attorney is Maureen McLeod.
I'll go to 11 and 12, Mr. Coleman.
11 and 12 is Mr. White. Okay.
Judge, I'll just interject. I'll call Maureen now, tell her you guys are waiting.
Thank you so much. Thank you, Mr. Murphy. Alante Coleman is accused of terroristic threats and simple assault from March 26, 2022, and case number 22 CR 001739F. He has also a simple battery family violence charge from December 3rd, 2021. Oh, excuse me. Yep, that's correct. He does have a second case for simple battery family violence under case number 22 CR 075F. Mr. Coleman, you've been advised of your rights. Your attorney is Mr. White. And I understand this is going to be a plea for both cases. Is that correct?
Yes, Your Honor.
Okay. Mr. Coleman, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. And Mr. Scirocco, what's the plea offer for Mr. Coleman?
Yes, Your Honor, for Mr. Coleman on position 11, the terroristic threats and acts and the simple assault. On count 1, 12 months, served 30 days, credit for time served, balance suspended. No further violent contact with law enforcement, no firearms. As for count 2, 12 months probation concurrent with count 1. No further violent contact with law enforcement, no firearms. For the simple battery family violence, 12 months suspended consecutive with 22 CR 001739F. No further contact with Kiara Owens. Stay away from 3230 Cushman Circle in Atlanta, and no firearms. We spoke more recently, at least, with Miss Owens with respect to the state's recommendation here. She stated that the defendant has ruined her life and her face and made her lose a job that she was at for 10 years. She wants no contact with the defendant or anyone associated with the defendant. If we could sound for Miss Owens when appropriate, and we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
All right, 2 things. First of all, Kiara Owens, if you're on Zoom, this is the time to unmute and start your video. The second thing is both the cases, the probation is going to be balance suspended. So once he has completed the jail time, and I'm looking at, this is to serve 30 days. His jail time is 12 days. So he will have what, 3 more days to serve at the jail?
Judge, he did 184 days back in 22 from January 5th until July 7th.
Okay, that was for the felony case. And is he
Now, Judge,
still serving a sentence for that case?
Judge, my understanding is it's listed under position 12 that he did a number of days in jail.
Oh, okay, let me see now. Well, I see it was, yeah, I see that he was booked in. He's got for
And then-
January 5th, 2022. He was booked in on January 5th, 2022. Then he's March 26th, 2022. Well, if the sheriff gives him credit for that time, but the March 26th, 2022?
That is
Yeah.
case for 11.
Yeah, he was booked in on January 4th, 2026 on a U.S. Marshal hold as well.
Okay.
From January 5th, 2026.
Okay. Judge, I understand it, but our understanding is that he's more than completed all of the time. He's got 103 days listed on position 11.
I
And
would agree with you, Mr. White. Mr. Scirocco, any comment on his time served?
State can't advise on that, Judge, per policy.
Okay. That will be up to Sheriff Labat if he wants to release him. I will give him credit for the time that he served back on January 5th, 2022, and when he was released from jail on July 7th, 2022, and looks like he was rebooked at the Fulton County Jail based on a U.S. Marshal hold. I have another question then. Is Mr. Scirocco, the state wants him to have no contact and stay away, but technically this sentence would have been completed once I complete this hearing. So Kiara Owens, y'all probably have to reach out to her and tell her that if she still believes that Mr. Coleman is a threat to her, she would need to request a protective order from the appropriate Superior Court.
I'll let her know. We'll reach out, Judge. Thank you.
All right, thank you. And I'm sorry, Mr. White, so do you so stipulate at the present time?
We do, Judge.
All right. Mr. Coleman, have you consumed any medicine or alcohol recently?
No, ma'am, but I had something to say though.
No. There's nothing,
It is something to say, like.
can't do anything. You can't help yourself in any way.
I'm not trying to help myself, but I want to make sure that y'all understand that I got a 12-year sentence in the feds. Like, this could have been,
Stop.
yeah, about no Kiera Owens.
It doesn't, then don't worry about it. It's time served, you're done, and there's nothing that you need to address the court with. Only bad things can happen by doing that.
I'm gonna speak for myself. I don't care.
Do you want to accept a plea offer?
I'm
that we talked about?
still gonna state what I want to state though.
Mr. Coleman, you are represented by defense counsel, Mr. Tom White. And I assume that you've already spoken to Mr. White about your 2 misdemeanor cases in state court.
Yeah, they could have been resolved.
If you decide to accept the plea offer today, that would close these 2 cases out. And then the only other matter that I can see is your U.S. Marshal hold.
I'm ready to get there. I'm tired of this. This is stressing me out. Yeah.
So, if you'd like,
I plead guilty and I'm ready to get out y'all way, please.
you won't be released. You will be released to
know
the
I'm not
U.S.
gonna-
Marshal hold.
He understands.
I'm very aware of that, and that's what's
Okay.
making it stressing right now, because I know this could have been resolved. I've been locked up going on 5 years.
Mr. Coleman, again, have you consumed any medicine or alcohol recently?
I got great sense.
And have you understood what's going on in your 2 cases today?
Yeah, that they could have been resolved.
Are you satisfied with your attorney?
I plead guilty. I'm ready to go.
I appreciate the fact that you are stressed out and frustrated, but if you don't let me do my job in order to ascertain whether you are entering a plea that is knowingly, voluntarily, and freely, I will reset this case for another day, another time. So will you let me do my job without interrupting and simply answering the questions?
Yes, ma'am. And if you need to-
Yes or no?
Go ahead.
Thank you. Are you satisfied with your attorney?
Yeah.
And have you understood that if you decide to plead guilty to these charges, you would have to give up your right to a trial? You will not go back to a courtroom to face a judge or a jury. You will not be able to confront your accuser. You will also not get the opportunity to present any legal defenses and arguments to the jury, and the state won't have to carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these constitutional rights?
Yes.
How do you plead to,
Guilty.
Let her finish. Let her finish.
how do you plead to terroristic?
Guilty.
Let her.
All 3 charges.
If you interrupt me one more time, I will reset this case to the end of the month. Do you understand? Yes or no?
Yes, you asked me to do how I plead, and I said guilty.
I haven't completed my sentence.
Oh, okay. I wasn't aware of that.
How do you plead to 2 counts, terroristic threats and simple assault from March 26, 2022?
Guilty.
How do you plead to simple battery, family violence from December 3rd, 2021?
Guilty.
For the terroristic threats, your sentence is 12 months to serve 30 days, credit for time served, balance suspended. With regards to the simple assault, it's 12 months concurrent with count 1, balance suspended. For the simple battery family violence conviction, the sentence is 12 months suspended. That concludes your 2 cases. You will be released to the U.S. Marshals hold as soon as they arrive at Fulton County Jail. Thank you.
Thank you, Judge.
Thank you, Mr. White. We have Miss McLeod on the Zoom. Which case
Good
was?
morning, Your Honor.
Good morning, Ms. McLeod. I guess you heard the summons from Mr. Murphy? Smoke signals, something? Okay,
Yes, Your Honor. I was in court elsewhere.
understood. Thank you.
DeMontes,
And remind me again,
what DeMontes?
position, I see it, I see it. Thank you. J. Montez Kane. Mr. Kane has been advised of his rights and the two positions on 8 and 9. Your attorney is Miss Maureen McLeod. Ms. McLeod, how would you like to proceed with Mr. Kane's cases?
Well, I do have to speak with him, Your Honor. I haven't been able to speak with him yet. The state has an offer which I do need to discuss with him.
Do you have the offer?
I do have the offer, Your Honor.
All right. Please contact the jail at courtroom 2 so that they can arrange for you to speak with your client. Thank you.
Thank you, Your Honor. Is it possible for them to give me a call?
Let's see. Deputy, would you happen to have Miss McLeod's number?
We do.
Okay. They will call you. Thank you.
Thank you. Thank you, Your Honor.
Mr. Kane, your attorney is going to call the jail courtroom and speak with you. All right. Can I proceed to ACDC? Or the individual who is grooming himself at South Annex, who is that?
I'm sorry, I have Miss Brown, position number 7, please.
7, Jasmine Brown. Who represents Jasmine Brown? Mr. Bartel, is that you?
Yes, ma'am.
Is that from our 11 a.m. calendar?
No, I'm handling the ACD cases on the SAP calendar.
Okay, all right. Position 7, Jasmine Brown. This is, she's charged with battery from December 31st, 2025. Case number 26CR025B. Ms. Brown, you've been advised, you have a right to remain silent. Anything you say in open court or this virtual proceeding, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Presently, your attorney is Mr. Paul Bartel. Do you see him on the screen? I need you to put your hands down and pay attention to the screen, please. Thank you very much. Mr. Bartel, how would you like to proceed with the case involving Jasmine Brown?
Well, Ms. Brown, can you hear me okay? All right, you're going to have to speak up. I don't think the microphone is very good.
No, she's muted right now. South Annex, please unmute.
It's a female at ACDC, Judge.
Oh, ACDC, please hold. Please hold. Your client's at South Annex, correct, Mr. Bartel?
No, Your Honor, she's at ACDC.
Oh, I'm sorry. I thought we were dealing with South Annex. Okay, sorry. Ms. Jasmine Brown is at ACDC. And Ms. Brown, do you see your attorney on the screen? Yes or no? Speak up. Okay, I think she said yes. So.
Yeah, you have to speak up, Ms. Brown. That microphone is not very good.
Yes.
Okay.
Thank you. All right.
Yeah,
And
so,
yes, Mr. Bartel, how are we proceeding with Ms. Brown?
well, Your Honor, Ms. Brown had indicated yesterday that she was going to consider whether she wanted to accept the state's offer. Ms. Brown, do you still want to plead not guilty, or do you want to plead guilty?
With what we discussed yesterday, I can plead guilty and take the classes.
Okay, and you understand what the conditions of the plea are?
Okay, Mr. Bartel, if we're going to have a discussion like this, you'll need to call ACDC and speak with her on the phone. This is
Okay,
going to be privileged communication between the two of you.
Okay, well, Your Honor, we can do that. Do you want to do the other ACD cases now, or?
Do you represent all the folks at ACDC?
I do, Your Honor.
All right. Deputy, Ms. Brown will have to speak with her attorney to make a decision as to how she would like to proceed. Who do we have next? At ACDC?
Position 26 and 27, please.
Thank you. Aisha Hammock has a case for theft by shoplifting from May 19th, 2025, under case number 25 CR 28618. And she has a bench warrant from July 23rd, 2025, under case 26 FTA 064. Ms. Hammock, you've been advised of your rights, and your attorney is going to be Mr. Bartell. Mr. Bartell, how are we proceeding with Ms. Hammock?
It's a negotiated plea, Your Honor.
All right, sir. Ms. Hammock, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up.
Yes.
Excellent. Okay. The microphone's not very good, so you'll need to really speak very aggressively into the microphone. Mr. Scirocco, what's the recommendation for Ms. Hammock?
Yes, Your Honor. On position 26, the shoplifting offense, the state's recommendation is 12 months, balance suspended. We're asking for a social worker visit to meet with her, assess for housing, and see what benefits that might be available to her. Stay away from 2045 Donald Lee Hollowell Parkway in Atlanta. That is the Family Dollar at that location. Upon acceptance of the plea to this charge, the state will agree to no pros. Position 27, the FTA. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea.
We would so stipulate, Your Honor. I've spoken with Ms. Burgess, who's here today, about seeing Ms. Hammock before she's released, and we would ask the court to accept the agreement.
Ms. Hammock, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your cases?
Yes.
Are you satisfied with Mr. Bartell's services?
Yes.
If you decide to plead guilty to theft by shoplifting, you would have to give up your right to a trial. You will not go to a courtroom, face those accusing you of this charge. The state won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of theft by shoplifting?
Guilty.
Repeat.
Guilty.
Your sentence is 12 months suspended. Before you're released from the jail, you would need to speak with a social worker to get you assistance for housing and any kind of benefits. Also, you are not allowed to return to the Family Dollar store at 2045 Donald Lee Hollowell Parkway. If you are seen anywhere near that store, you will be arrested. Thank you.
Thank you, Your Honor.
And her bench warrant is null prost.
Thank you.
The next case at ACDC.
Now position 1 and 2, Judge.
Deputy, repeat the case number.
I have add-on position 1 and 2.
Oh, okay, thank you.
And that will be a plea as well, Your Honor.
Thank you, sir. This is State versus McKayan Burnett. Ms. Burnett has one case, 23 CR 6171E, and she has a bench warrant for 26 FTA 037. With regards to the underlying case, she is charged with giving false information to an officer, willful obstruction of a law enforcement officer, simple assault, and giving a false name, address, or birth date. Incident date appears to be October 11th, 2023. Ms. Burnett, you've been advised of your right to remain silent, and your attorney is going to be Mr. Bartell. Was this a plea as well, Mr. Bartell?
It is, Your Honor. We just have a couple of questions about a couple of the conditions, but we can proceed and talk about that.
I don't know what the plea offer is, so I'm just going to proceed as if this is a plea hearing. and we'll see where we go with this. Ms. Burnett, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Scirocco, what's the plea offer for Ms. Burnett?
Yes, Your Honor, for the underlying case on count 1 and count 4, the giving false information charges, they're both 12 months probation concurrent with count 3, which is a simple assault. For count 2, 12 months probation concurrent with count 3 as well, $300 fine and an Op 21 law and decision-making course. And for count 3, it's 12 months served, 48 days, credit for time served. Balance probated, we are asking for BHET and MHET. No further contact with Amira Howell. I've seen the victim's name spelled 2 ways, Amira and Amara. Either way, stay away. No further contact with Ms. Howell. Stay away from Clark Atlanta University, premises and property, and 40 hours community service. Upon plea to the underlying offenses here, the state has agreed to null pros, the failure to appear. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea, and we would like to sound for Ms. Amara Howell.
Well, Your Honor, we would stipulate for the basis of the plea. There are just 2, I guess, issues we have a question about or would ask to be heard on. I understand the state's recommendation for the 3rd count is both a BHET and an MHET. I'm not sure of the distinction with those terms. Sometimes people do use them to mean different things. But if the state's intent is that she get an evaluation to determine what services are needed and to follow up with those services, I think that would be covered by MHET. I was just wondering exactly what the understanding is of the difference between those 2.
Mr. Scirocco, is there a particular reason why both are required? Do you believe there are MH issues or behavioral issues?
I believe there might be both here, Judge. So that's
Okay.
why we're asking for both.
I will allow for MH issues that might be more all-encompassing rather than a behavioral health evaluation. Any objection?
None, Your Honor. I think MHET would cover whatever might be needed.
Okay. Anything else, sir?
Well, Your Honor, I am advised by Ms. Burnett that she actually is currently enrolled in Clark Atlanta. We don't have any issue with a no further contact order, but she indicates that she is currently enrolled and has been taking online classes. So the stay away order may be problematic if she has to go there in person on some type of, official business.
Is Amira Howell a teacher, a professor, a student? What are we talking about?
She's a student, Judge.
Okay. Anything else?
No, that's it, Your Honor. We would just ask if the court would consider stay away from Clark Atlanta unless going there on official business.
She can continue with her online classes, but she's not allowed on the property until her probation is completed.
Okay, very well, Judge. And nothing further from the fence. We would just ask the court to accept the plea. She does live in Florida, so I had advised her that she's going to need to sign up with probation when she gets out, but we would ask that she be able to report by phone or online when she gets back there.
When does she plan to go back to Florida?
Ms. Burnett?
My aunt and my boyfriend are gonna let me stay at both of their houses until I'm finished with the terms of my conditions. I'm gonna do my community service and things here, and then I'm going to get the first flight back to Florida. So just whenever
Alright.
I'm done.
She will need some.
Oh, just for your edification, she is being held on a PI charge as well in Superior.
Okay. So, Mr. Bartel, once she begins probation, she will need to be in Georgia and report in person once a month until the terms of her probation are completed and that she's up to date with all her conditions and probation fees. After that, it will be non-reporting, And at that point, I guess she can return to Florida.
Thank you.
All right, very well, Your Honor. Thank you.
Okay. Ms. Burnett, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your two cases?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am. He's a great attorney.
Have you understood that if you decide to plead guilty to these 4 charges, you would have to give up your right to a trial? You will not go back to a courtroom to face a judge or a jury, to confront your accuser, to be able to present your defenses and arguments, and the state won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 2 counts of giving false information, willful obstruction of a law enforcement officer, and simple assault?
Guilty.
For counts 1 and count 4, the false information is going to be 12 months probation concurrent with count 3. For count 2, willful obstruction, that's going to be 12 months probation concurrent with count 3, with an addition of a $300 fine. She would need to pay the $300 fine at a minimum rate of $30 per month. For count 3, the simple assault, one more condition for the willful obstruction is that she must enroll in an Operation 21 law and decision-making seminar, and this must be enrolled and completed within 60 days of being on probation. For count 3, the simple assault, the sentence is going to be 12 months to serve 48 days, credit for time served. Once she is released from all holds, she will begin her probation. While she's on probation, she will enroll and complete a MH evaluation and submit to all treatment that's required. And she will complete all treatment and be compliant with all medication. She will have no contact with Amira Howell, and that means no contact in person or by any kind of electronic or phone means, and even on social media. She will physically stay away from all property belonging to Clark Atlanta University, and she's allowed to do her classes online. She will complete 40 hours of voluntary community service, and that must be done with any nonprofit agency, and it cannot be a church and it cannot be a school. Community service must be completed at a minimum rate of 5 hours per month. If she has completed all these requirements, if she's up to date with her fines and her probation fees, and she has not committed any probation violations, then her probation will be non-reporting. If she changes her address, she will need to let the court and probation know immediately. Thank you.
Thank you, Jen. It does look like she served 32 days. So I think there would be no additional time on this. So,
All
thank
right.
you.
But she's got the hold, so she can't report until the hold's lifted.
I didn't see that there were any other holds on her screen. I think there may be a pending case, but I didn't see that.
Oh, hold on. Let me issue a correction. It appeared on the face of the jailing screen, but when you click in, it doesn't look like it's currently a hold. So
I think that was
yeah,
originally
she should be fine.
All right. Yeah, looks like she was released on a surety bond, so that she does have an open case in Superior Court. But if she has no holds, then she reports to Fulton County Probation on Monday before 3 p.m., this coming Monday. And the FTA on position 2 is null pros. Thank you.
All right, thank you.
Judge, I would only interject that Monday's a holiday.
Shoot. Man, I completely forgot. Okay, report on Tuesday.
Murphy.
By the way, is probation? Oh my, they are closed. So thank you, Mr. Murphy.
Judge, on position 34, McGee, if we can reset that to Thursday, I've received Mr. Schrocker's offer, and it's he wants additional incarceration, so I need time to speak to Mr. McGee and warrant.
All right, deputy case with Antonio McGee is going to be reset to the SAP calendar next Thursday, and that's going to be January 22nd.
Thank you, Judge.
Your Honor, there is an ACDC case I wanted to ask about. Mr. Scirocco, too, number 39 to 40, Mr. Nime. I understand, well, he wants to plead not guilty, but I think there was a transfer request for that and it's been reset a couple of times.
It's certainly, yes, no, this case certainly has been reset, or at least one of them has. The other one came on more recently for the C
Okay.
calendar,
Mr.
but
Is Mr. Just 1 second. Is Mr. Naim at ACDC? Okay. Then let's hold off on Mr. Naim. Who do I have at ACDC right now?
I have Ms. Brown again, Mr.
Jasmine Brown. And
said she's ready for the plea. So.
okay.
Okay.
Mr. Bartel, am I assuming that, okay, let me see. Ms. Jasmine Brown, you've already been advised of your case and you were charged with battery, and Mr. Bartel received a plea offer. Mr. Brown, I don't know if you've had a chance to speak with her between the pleas that you've handled. Ms. Jasmine Brown, would you like time to speak with your attorney before you make a decision?
I spoke with him yesterday. I can speak today.
Could you repeat what you just said?
I spoke with him on yesterday, so I'm ready.
And are you entering a not guilty plea, or are you considering accepting the plea offer?
I'll accept the guilty plea offer.
All right. Mr. Bartel, are you satisfied to proceed?
I believe we're able to proceed, Your Honor.
26 CR 25B. Ms. Brown is accused of battery. Ms. Brown, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Scirocco, what's the plea offer for Ms. Brown?
For Ms. Brown, Your Honor, the offer is 12 months served, 30 days, credit for time served. That would be balance probated with a 12 anger management class course. Currently, we are recommending no further contact with Queen Fard, victim here, and stay away from 1524 Olympian Way in Atlanta. That this is out of an abundance of caution, the facts of the underlying case, but I do see Miss Fard here. As we've not spoken with her yet, if she wanted to provide input as to whether she wants contact or a stay away, and anything else she'd like to add, we would ask that the court sound for her. We would also ask that the defense stipulate a factual basis, venue, and ID for purposes of the plea.
Thank you, Mr. Bartel. This individual who's on Zoom under the name Queen F, if you are Queen Fard and you would like to contribute to this hearing, this is the time to unmute and start your video. All right. Ms. Brown, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in your case?
Yes.
And are you satisfied with your attorney?
Yes.
All right. For the next line of questionings, you don't have to sit up until I ask you. If you decide to plead guilty to this charge, you would have to give up your right to a trial in front of a judge or a jury. You will not get the chance to go back to a courtroom to face your accuser, challenge the charge brought against you and the evidence. You will not get a chance to present any legal defenses and arguments with your attorney, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of battery?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served. If you have completed the service time, you'll be released and you report to probation next Tuesday before 3 p.m. While you are on probation, you are to complete 12 anger management classes. You will enroll and start your first class within 45 days of being on probation. And then after that, you will complete all 12 classes consecutively without missing or skipping any of the classes. At all times, you are to stay away from 1524 Olympian Way in Atlanta, Georgia, and you are to have no contact with Queen Fard. You are to stay 200 yards away from her and not communicate with her in any way, form, or manner. Thank you.
Your Honor, if I could just address the stay away issue. Well, I don't think there's any issue with no further contact with Ms. Farb, but Ms. Brown advises me that the address 1524 Olympian Way, that is her father's home. It's not her mother's home. And she's been staying there. My client has been staying there, not her mother. So we would ask that she be allowed to go back to that address as long as her mother is not living there or not present.
She is allowed a one-time visit to the location with a police officer. Her first visit to that location must be with a police officer. If the police officer verifies with her father that Queen Farb does not live there, then the stay away will be lifted.
All right, thank you, Your Honor. And we would ask the court to consider waiving the first 2 months of fees. Has an LPN, but she's not employed at this time.
Denied.
All right, well, good luck, Ms. Brown.
I'll be back. I have to go take these 3, then I'll get the other 2, okay? Thank you.
Thank you. South Annex, who do we have, please?
Position number 51.
Thank you.
Yes.
This is Rashad DeMonte Stovall, accused of 2 counts of simple battery, family violence, and criminal trespass causing damage to property. Case 25 CR 7752E. Mr. Stovall, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, Mr. Dennis Murphy will be representing you. Mr. Murphy, how are we proceeding?
Judge, I wasn't aware that Stovall was my case.
Oh, I'm so sorry. You unmuted, so I just.
I'm sorry. Sorry about that.
Oh, sorry. Ms. Tucker, is that your client?
Yes, Your Honor.
I beg your pardon. Okay, I'm sorry. Mr. Stovall's attorney is Ms. Tucker. And Ms. Tucker, this is going, how are we proceeding?
This will be a negotiated plea.
Okay. Mr. Stovall, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah, ma'am.
Mr. Scarapa? Yes, sir. Please proceed.
Thank you, Judge. For position 51, the 2 counts of simple battery, family violence, and the criminal trespass and damage to property, which are counts 1 through 3, respectively. On count 1, 12 months to serve 180 days, credit for time served, balance probated. FFIP, no further contact with Aquila Oates. Stay away from 2315 Cushman Circle, Hidden Plains Apartments. And I'll confirm the, that is Cushman Circle.
Hidden Pine Apartments, is that correct?
Hidden Pine, yeah, yes, Your Honor.
Okay.
Count 2, also 12 months, serve 180 days, credit for time served, balance probated, 40 hours community service, MHET, no further contact, again with Miss Aquila Oates, and stay away from that same address. This would run concurrent with count 1. And for count 3, the criminal trespass, damage to property, 12 months, 80 hours community service, 12 months probation, 80 hours community service, no further contact with Aquila Oates, stay away from 2315 Cushman Circle, and that Hidden Pines Apartments. And this count 3 would run consecutive to counts 1 and 2. We are asking for continuous reporting here. And that is going to be all for the state. We would ask that defense stipulate a factual basis, venue, and ID for purposes of the plea. And if we could sound for Ms. Oates, who stated to us that she understands and agrees with the plea. The offer that the state's made.
Miss Akila Oates, if you're on Zoom, this is the time to unmute and start your video. I'm assuming that the possession of a pistol by someone who's 18, that charge from July 2025, is that a misdemeanor case with this court?
Let me
No,
see.
it's an SC
No.
case. All
Nope.
right. All right. And then he's got, all right, but you'll understand that he won't be released because, well, not because of the additional jail time, but because of the current felony case as well.
We understand.
Miss Tucker, does your client accept these terms, understanding that his probation won't start for significant period of time?
Yes, Your Honor. I did explain that to him, and we did discuss the open case. He does accept the terms as they were explained. So we do also stipulate for the purpose of the plea, Your Honor. We will request that if he completes all the terms as required in the first year, and once the second term begins, he completes the community service there if you allow for non-reporting.
And we would certainly object for that. Given
I am not inclined, based on the charges that were brought against him back on July 29th, 2025. He was released on August 1st, 2025. And soon thereafter, he was back in jail on December 3rd, 2025. Mr. Stovall, given his age and given the nature of the charges and the multiple cases, I'm going to require him to be on probation every month for the next 2 years or the year and a half after he's released from jail.
Yes, Your Honor.
Mr. Stovall, given these parameters, would you like to proceed with this plea or would you like to enter a not guilty and have the case set for trial? Mr. Stovall, I'm asking you.
I take it.
You will do what?
Plead guilty.
Okay. All right. And Miss Tucker, I'm sorry, do you so stipulate?
We do so stipulate for the purpose of the plea.
Thank you. Mr. Stovall, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
I beg your pardon?
Yes, ma'am.
And are you satisfied with your attorney services?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
And has your attorney explained to you that if you enter a guilty plea to these charges, that your probation won't begin until all your other holds have been resolved?
Yes, ma'am.
And you understand that if you accept this plea, you will have to serve additional jail time.
I know how long the jail time will be.
Well, it is going to be to serve 180 days, and you're going to be given credit for 44 days. So that would be in excess of 50 more days. But even if you've completed the jail time, you may still be at the Fulton County Jail if you're being held on other cases.
I understand.
Are you still willing to move forward with this plea?
Yes, ma'am.
And has it been explained to you that if you plead guilty to these charges, you would have to give up your right to a trial? You will not go back to a court of law to face a judge or a jury, to confront your accuser, to be able to present any defenses and arguments against the evidence brought against you. And the prosecutor won't have to prove these charges by a preponderance of the evidence. Are you willing to give up these rights?
Yes, ma'am.
You understand there's no right to an appeal, and these will be convictions on your record.
Yes, ma'am.
How do you plead to 2 counts of simple battery family violence and 1 count of criminal trespass causing damage to property?
Guilty.
For count one, the sentence is going to be 12 months to serve 180 days, credit for time served 44 days. Once he's released on all holds, his probation will begin and he will report to Fulton County Probation within 48 hours of being released. While on probation, he will enroll in a domestic violence intervention program within 30 days of being released, and he will complete all 24 classes with a qualified school without missing or skipping any classes. He's to have no contact with Akilah Oates, to stay 200 yards away from her, and to stay away from the entire Hidden Pines apartments or the location at 2315 Cushman Circle in Atlanta, Georgia. For count two, it's 12 months to serve 180 days, credit for time served 44 days, concurrent with count one, balance probated, to complete 40 hours of community service, to enroll and, to undertake a MH evaluation within 60 days of being released and comply with all treatment and medication. Again, no contact with Akilah Oates and to stay away from the same location. Finally, for count three, it will be 12 months probation consecutive to counts 1 and 2. He will continue to report to probation every month, in which he will have to complete an additional 80 hours of community service at any nonprofit agency. Again, no contact with Akilah Oates and stay away from the same location.
Yes, ma'am.
Thank you.
8 and 9, Mr. Kane.
Ms. McLeod, how would you like to proceed with Mr. Kane?
Your Honor, this is going to be a negotiated plea.
All right. Mr. Kane has been advised of his rights. His case is 25 CR 573E, accused of battery and criminal trespass, and he has a bench warrant. Mr. Kane, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am.
Mr. Scirocco?
Thank you, Your Honor. For count one, the battery, the state's recommendation is 12 months, serve 120 days. Credit for time served, balance probated, 12 week anger management, 40 hours community service, no further contact with the victim Zakeith Sanders. Stay away from 3164 Cushman Circle Southwest in Atlanta. We're recommending restitution for physical therapy, open for 30 days. No drugs, alcohol, or weapons while on probation here. Count two, 12 months probation to be served consecutive to count one. Again, no further contact here with Mr. Zakeith Sanders. Stay away from 3164 Cushman Circle Southwest in Atlanta. And restitution in the amount of $500 to Mr. Sanders. Upon acceptance of the plea, the state will null pros the FTA, that is position 9. We have spoken with Mr. Sanders, and he understands with and agrees with the plea offer. He stated that he doesn't have any medical bills. However, and with respect to that, we need to clarify and make sure that there is nothing further needed for physical therapy. So that's why we're asking for that to remain open. However, he states the defendant did steal items rounding up to about $700. We don't see that anywhere in the warrants presented to us, so we are not asking for restitution on that basis. That is all for the state. We would ask that the court sound for Zakeith Sanders, and we would ask the defense stipulate a factual basis, venue, and ID for purposes of the plea.
We do so stipulate.
Thank you. Zakeith Sanders, if you're on Zoom, this is the time to unmute and start your video. All right. So there's no $500 restitution on count 2. And with regards to keeping the case open for restitution for physical therapy, I'm going to decline that in the event that Mr. Kane decides that he wants to get compensation for physical therapy for this incident from November 2024. He may file a civil suit against Mr. Kane and recover for any physical therapy that he received for his injuries in this case.
The $500 restitution in count 2 was with respect to the damage done to the window, as opposed to anything with respect to the
Oh, no,
battery.
I understand that, but you have declined that, right? You said,
No, with respect to count 1, we're not aware of medical bills per se. Physical therapy being distinct is what we would want to clarify as to whether there is any restitution needed for that. So we are asking.
is there any indication that he has received physical therapy since November 2024? He's not even here to verify that. Now, that's out. So let me just get, Mr. Scirocco, when you said you didn't have any evidence of damage to items, and so when you said you're not going to pursue, that was not the $500 there?
No, Judge, that was this. He stated to us that there were $700 worth of items stolen. This is not with respect to property damage.
Okay,
there's
so
no theft charge.
Okay, so that restitution for $500 is for the window that was alleged in the warrant?
Yes, Judge.
Okay, I'll go with that one. Okay, Mr. McLeod, any comment about the restitution issues?
Your Honor, since the court is going to disallow the physical therapy.
No, I'm not going to disallow. I'm going to decline. He can pursue it in a civil case.
Right, I understand. I'm fine with that, Your Honor. I would ask if the court would allow to waive probation fees for the first 3 months, since my client will be in jail. They're asking for 120 days. So of course, by the time he gets out, he'll have to situate himself, get a job and so on. So he will not be immediately be able to start paying probation fees. So at least the first 3 months would be waived, Your Honor. I believe my understanding is he's only spent about 17 days so far, based on what he tells me, but I was not able to ascertain myself.
18 days, credit for time served, 18 days. And I will waive probation for the first 2 months once he begins probation. Of course, you understand that he's got other matters holding him at the jail where he will not be released, well, for some time. I don't know, but he's got, well, you understand he's got other matters.
Yes, Your Honor.
Okay. All right. Mr. Kane, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your misdemeanor case and your bench warrant?
No, I want to take this to trial.
Oh, okay. Miss McLeod, it appears that your client has changed his mind and he wants to.
Oh, he must have, because we had a long discussion about this. Okay. In that event, Your Honor, we would like the case to be placed on the next available jail trial calendar.
All right. Will you be filing a waiver of arraignment, or shall I?
I've already
arraign?
done that, Your Honor. I've already done that.
This the battery criminal trespass charge and the bench warrant are going to be further notice for jail jury. Positions 8 and 9. Thank you.
Thank you, Your Honor. May I be excused until the 11 o'clock calendar?
Yes, thank you.
Thank you.
Okay. South Annex, who do we have? Oh, I'm sorry. Hang on, South Annex, hang on. ACDC has just popped in. Yes, who do we have?
Position 41 and 42, Judge.
Oh, you were fast, Deputy. Okay, 41 and 42. I have Mia Oliver. Mia Oliver has case 25 CR 1558F, accused of criminal trespass and willful obstruction from March 21st of 2025. And she's got a bench warrant under 26 FTA 052. Ms. Oliver, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning is going to be Mr. Paul Bartel. Any prior, excuse me, no, this is not C calendar. How are we proceeding, Mr. Bartel?
It's a negotiated plea, Your Honor.
All right. Ms. Oliver, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up.
Yes, ma'am.
Excellent. Thank you. Mr. Scirocco?
Yes, Your Honor. For count one, for position 41, the criminal trespass, state's recommendation is 12 months, serve 80 days, credit for time served, balance probated, behavioral health evaluation, any recommended treatment. Stay away from the Greyhound bus station that is at 232 Forsyth Street Southwest in Atlanta, and 20 hours community service. As for the willful obstruction, count two, 12 months probation concurrent with count one, and a $300 fine. Upon acceptance of the plea, the state will null pros position 42, the FTA. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Mr. Bartel?
We do so stipulate, Your Honor.
All right. And does she still maintain a residence at Gateway, or does she plan to resume it?
They also help throughout I know it's a place in downtown that I have to go visit, and they said if I have a mental health evaluation, then I can get help with housing. I don't have to use Gateway anymore. It's 106 and 110th Street or something like that, where they have doctors and it's
Miss Oliver, if you decide to accept this plea offer, you will be on probation. While you're on probation, you must maintain a verifiable address.
Okay.
Either at Gateway or someplace that you would need to provide within 30 days of being released.
Okay, then yeah, it'll be.
Yes,
Okay.
we've made a social work referral, Your Honor.
Okay. Miss Oliver, have you consumed any medicine or alcohol recently?
Get the medicine I took this morning.
Are you still able to understand what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has it been explained to you that if you pled guilty to these charges, you would have to give up your right to a trial? You will not be able to go back to a courtroom to face a judge or a jury, to be able to confront your accuser, challenge evidence brought against you, have the state carry its burden to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights? Repeat.
Yes, ma'am.
How do you plead to criminal trespass at the Greyhound station and willful obstruction of an officer?
Guilty.
For the criminal trespass, your sentence is 12 months to serve 80 days, credit for time served 40 days. So if you have no other holds, you will be released within 24 hours, but you must report to Fulton probation on Tuesday before 3 p.m. While you are on probation, you will enroll and complete a behavioral health evaluation and submit yourself to any treatment. This must be done within 60 days of being released. You will report to probation every month, and you'll also be required to do 20 hours of community service with any nonprofit agency. Cannot be a church, and it cannot be a school. The community service must be done at a minimum rate of 5 hours per month. At all times, you have to stay away from the Greyhound station at 232 Forsyth Street in Southwest Atlanta. For the willful obstruction, it's going to be 12 months concurrent with count one, where you will also need to pay a $300 fine. And this $300 fine must be paid at a minimum rate of $30 per month.
And would the court consider waiving the first 2 months of probation fees?
Oh, yes, sorry. Yes, I will. 2 months waiver.
Thank you.
I have a question. So you're releasing me on the circumstances that I be on probation, right?
You are on probation from this point onwards. You report on Tuesday before 3 p.m.
Okay.
If you don't report, well, you'll be back where you are.
Okay, thank you.
All right, thank you, Judge.
Thank you.
Thank you.
Good luck, Ms. Oliver.
Thank you.
And the bench warrant is null prost.
All right, thank you.
Deputy, we good?
I have to go. I'm gonna take Miss Oliver back and I have one more meal.
All righty. Now remember, she's fast, so let's go to courtroom 2 or South Annex.
So South Pass number 17, Mr. Fleetwood.
Okay.
Judge, good morning. That's my case, and I need to speak to Mr. Fleetwood if I can get to a breakout room. I have not been able to convey any offer to him.
Okay. South Annex, please monitor the screen. We're going to place your Mr. Fleetwood into a breakout room. Miss Lewis, Miss Grace, could you please place South Annex and Mr. Dennis Murphy, his screen name is iPhone.
It's Miss Champion, Judge.
Oh, is it Miss Champion? Sorry. Miss Champion, if you could change that, place both of them in a breakout. Thank you. Courtroom 2, who do we have?
We gonna have position 58, Mr. Thomas.
Gregory Thomas is accused of battery and simple assault from December 31st of last year under accusation 26 CR 005G. Mr. Thomas, you've been advised of your rights and your attorney is going to be Ms. Tucker. Ms. Tucker, this is going to be
Plead, Honor.
negotiated plea. Okay. And Mr. Thomas, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Scaraco?
Yes, Your Honor. For the battery charge, that is count 1, and the simple assault charge, that is count 2. On count 1, the state's recommendation is 12 months, served 90 days, credit for time served, balance probated, 12-week anger management course, no further contact with Ms. Tamala Donald. Stay away, definitely emphasize this wholeheartedly. Stay away from 911 Joseph E. Boone Boulevard, Northwest in Atlanta. That store there, 60 hours community service. And count 2 would merge with count 1. Ultimately here, we would definitely object to any sort of non-reporting or termination. We would ask the defense stipulate a factual basis, venue, and ID for purposes of the plea, and if we could sound for Miss Donald at this time.
Tamala Donald, if you're on Zoom and would like to contribute, please unmute and start your video. What was the store, Mr. Scaraco, by any chance?
I'll verify
Or is it
that,
a
Your
strip
Honor.
mall?
Yeah.
It should be around that day.
Okay, and he's been in custody for this case for 15 days. So that means this will be additional jail time.
It's listed as being the M&M grocery store, Your Honor.
All right. Miss Tucker, do you so stipulate and does your client accept these terms?
Yes, Your Honor. We've discussed the terms. He is agreeable, so we do so stipulate for the purpose of the plea. Your Honor, we will request to the court that the first 3 months of probation fees be waived. He will have an additional month to serve of jail time for this plea. So he will have to reestablish income once he's released.
I will wait for Tillis 2 months. And he'll need to provide us with a valid or verifiable mailing address within 30 days of being on probation.
Yes, Your Honor.
Mr. Thomas, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yeah.
Are you satisfied with your attorney?
Yes.
And has she explained to you that if you decide to plead guilty to these charges, you would have to give up your right to a trial in front of a judge or a jury? You will not go back to a courtroom to face your accuser, to be able to present your defenses and arguments through counsel, and the state won't have to carry its burden to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead? To battery and simple assault?
Yes.
Repeat?
Yes.
For the battery charge, your sentence is going to be 12 months to serve 90 days. Credit for time served 15 days. Once you have completed your additional jail time, and if you have no other holds, you will report to Fulton County Probation within 48 hours. Your first 2 months of probation fees shall be waived, but while on probation, you will complete 12 anger management classes. You're to enroll in those classes within 60 days of being released and to complete all 12 classes at your expense without missing or skipping any of them. You are to have no further contact with Tamala Donald. Stay 200 yards away from her and do not communicate with her in any way, form, or manner. Stay 200 yards away from the M&M grocery store located at 911 Joseph E. Boone Boulevard in Northwest Atlanta. If you're seen anywhere near that location, including the parking lot, you will be arrested and your probation may be revoked. You're also to complete 60 hours of voluntary community service with any nonprofit agency, but it cannot be a church and it cannot be a school. And you're to do the community service at a minimum rate of 10 hours per month. Count 2, simple assault, that will merge into count 1. Thank you.
All right, number 61, Mr. Velazquez.
Ms. Tucker, how are we proceeding with Mr. Velazquez?
It'll be a negotiated plea, Your Honor.
And do we need a, I do see we have Miss Chansey on Zoom. Is this the interpreter case or is it another one?
No, Your Honor, I didn't request an interpreter.
I'm a proud citizen. I do want to note that,
No, sure.
I have Gonzalez Ramirez, Your Honor.
Okay, thank you, Miss Chansey.
You're welcome.
This is Jason Velasquez, accused of criminal trespass and willful obstruction of a law enforcement officer from January 2nd of this year under case number 26 CR 053E. Mr. Velasquez, you've been advised of your rights and your attorney is Ms. Tucker. Will you please raise your right hand for the plea? Do you swear and affirm that the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Repeat.
Yes, Your Honor.
Mr. Scirocco, what are the terms of your offer?
Yes, Your Honor. On count 1, the criminal trespass, the state's recommendation is 12 months, served 26 days. Credit for time served, balance probated, BHET, stay away from 1000 Marietta Street, Northwest in Atlanta, and 30 hours community service. I believe that address there is called Brickworks. Count 2, the willful obstruction, the state's recommendation is 12 months probation concurrent with count 1, $300 fine. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. And that is going to be all for the state. We would object to non-reporting given the facts here, but that's all.
Ms. Tucker, do you so stipulate and does your client accept these terms?
Yes, Your Honor, we do so stipulate for the purpose of the plea.
Is your client a South Carolina resident?
Yes. I wish to transfer though. I just give me time and I can report with probation and everything. I wish to transfer, just give me some time. I'm kind of not homeless, but I'm living on my car. I could definitely get my report and everything. I'm capable of providing an address for the next 2 months if you could waive that as well. I'm really pick and choose.
Before you were so rudely interrupted, Ms. Tucker.
He did explain to me that he's a South Carolina resident. So my request was going to be that he be allowed to report over the phone. But then he did follow up and say he could stay in Fulton to complete the terms. So I do believe he will be here.
Yeah,
Is that correct?
that's
Okay.
That's fine.
Okay.
So we'll have to provide the court with the updated address.
Understood. All right. The recommended offer requires him to complete 30 hours of community service and pay a $300 fine. He's also required to complete a behavioral health evaluation and submit to any treatment that's required, and also to complete 30 hours of community service. All these conditions must be completed before he's allowed to travel back to South Carolina. His probation will continue in Fulton County until all these requirements are completed and his probation fees are up to date. Given the current circumstances, Mr. Velasquez, would you like to continue with this plea offer, or would you like to enter a not guilty plea and schedule it for trial?
I wouldn't. Animals plea, I do not plead. I'm just gonna say I don't plead. I reserve all rights.
Do you want to accept the plea?
I reserve all rights, but accept the charges for their value. I do want to say that.
Do you want to accept the plea offer from the court?
I'll take the plea offer for now, respectfully.
Just to confirm, you are accepting the plea offer, is that correct?
But I still reserve all rights.
Yes or no? Are you accepting the plea offer? Speak up.
Yes, ma'am. Yes, Your Honor.
All right, Mr. Velasquez, have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in your case?
Yes, ma'am. Yes, Your
You
Honor.
need to speak up a little louder.
Yes, Your Honor.
And are you satisfied with your attorney?
Yes.
Repeat.
Yes.
If you decide to accept this plea offer, you would have to give up your right to a trial. You will not be able to go back to a courtroom to face your accuser. You will not be able to challenge the evidence brought against you, present your own legal defenses and arguments through counsel, and the prosecutor won't have to carry his burden and prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to criminal trespass and willful obstruction of a law enforcement officer? How do you plead, sir?
Say guilty.
On the criminal trespass, your sentence is going to be 12 months to serve 26 days, credit for time served 13 days. You don't have any other holds at the present time, so you will report to Fulton County Probation on Tuesday before 3 p.m. You will continue to report to probation in person in the Fulton County office until all the conditions of your probation are completed and your probation fees are up to date. I will waive your probation fees for the first 2 months. And while you report to probation in person, you will also complete a behavioral health evaluation and submit to any treatment that's required. That must be done within 45 days of being released. At all times, you have to stay 200 yards away from the complex known as Brickworks, and that is located at 1000 Marietta Street in Northwest Atlanta. You'll also be required to complete 30 hours of voluntary community service at any nonprofit agency. It cannot be a church and it cannot be a school, and you will complete that at a minimum rate of 5 hours per month. For the willful obstruction, your sentence is 12 months concurrent with count 1, with an addition of a $300 fine. And you will pay that $300 fine at a minimum rate of $30 per month. If you have completed all these requirements, your fine has been paid off and your probation fees are up to date, then your probation may be non-reporting if and only if you move to South Carolina. We will need a verifiable mailing address in South Carolina and proof that you are traveling to South Carolina. If you continue to reside in Atlanta, you will continue to report to probation once a month until the remainder of the 12 months is completed. Any questions?
My car was left at QT. Am I allowed to go back to QT to get that?
You are allowed a one-time visit to the QT gas station if it is at that location. You need to pay attention. You are allowed a one-time visit to that location if it is part of the prohibited location, and you must have a police officer escort you to that location.
Understood.
But if you have a criminal trespass from the QT location, Then you will require a police escort.
Understood.
That concludes this case. Thank you.
Let me check, double check. I think it's the president.
Thank you.
Quorum two, next case, please.
Have position 15 and 16 of ACDC.
Okay.
I was telling him I would see. What's your name?
This is
Judge.
Frank. Sorry, Mr. White. Yes, sir.
We were unable to locate him yesterday. We thought he was at Fulton County, apparently. So I'm going to need a breakout room to speak with him.
All right. Miss Champion, if you could place ACDC and Mr. White in a breakout room, please. All right. Mr. Murphy, you were in a breakout, or somebody else was in a
Judge,
breakout?
I've come out of the breakout and we've announced that that's going to be a plea on Fleetwood number 17 when you reach us.
Okay. ACDC is going to a breakout with Mr. White. Courtroom 2, who do you have?
Yeah, this is 54 and 55, Mr. Taylor.
Okay. Courtroom 2, please hold. I'll be with you very shortly. South Annex, Mr. Fleetwood?
Yes, ma'am.
All right. You've already spoken to your attorney. Okay, then Mr. Fleetwood is position 17. This is Travante Lamoris Fleetwood, case 25 CR 8091, accused of simple battery family violence from August 5th, 2025. Mr. Fleetwood, you've been advised of your rights and your attorney is Mr. Murphy. May you please raise your right hand for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Put your hand down. Thank you. Mr. Scirocco, what's the offer?
Your Honor, on the simple battery family violence, the state's offer is 12 months, serve 180 days, credit for time served. The complete FFIB, have no further contact with Jemiah Colsey or her children. Stay away from 653 Boulevard, Northeast in Atlanta. We did speak with the victim. She stated she understands and agrees with the plea offer. She was concerned with the no contact as the defendants or the defendant's family will watch the child sometimes while she's at work. However, given the history here, which I can absolutely go into, we are recommending no further contact whatsoever with either her or her children here. If we could sound from Ms. Colsey when appropriate, and we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
We do so stipulate.
I've got a credit for time served.
I've got 115 days, Judge.
Okay. We're on the same page on that. Okay. And is there a Jemiah Colsey on Zoom who would like to unmute and start a video? Okay. This is presently a no further contact with Jemiah Colsey or her children. Mr. Murphy, does Ms. Colsey share the same children with your client?
Judge, my client has one child, a 1-year-old, and it was my understanding that that there would be allowed just third-party contact for purposes of visitation and occasional child care. But he would otherwise he would agree to no further direct contact with Ms. Colsey as part of the plea.
I have no further contact with Jemiah Colsey or her children, so he can file a legitimation case while he's on probation to get a court-ordered family parenting plan. But right now, it will be no contact.
Judge, will accept that. Judge, this was simple battery. There was no discernible injuries. We would ask the court to accept a NOLO plea, given age and limited history.
We would object, Judge.
Mr. Murphy, given his current probation violation and his current pending felony charges, the request is denied.
Duly noted. Then we will proceed with a guilty plea.
Okay. And the other matter I have to address is what was brought up by Mr. Scirocco, is that if the child or children are at his family's home, he cannot be there because he has to maintain a 200-yard distance from them.
Yes,
Is
Judge.
that where he plans to live?
No. Well, he will be returning. He will be returning to his parents' home because he has no discernible trade. He's a high school graduate, and he has lost his last position,
All
so
right.
he is unemployed. He will be staying with his parents.
In that case, Mr. Scirocco, please advise Ms. Coldy that she needs to find alternative childcare locations.
Understood, Judge.
All right. Mr. Fleetwood, have you consumed any medicine or alcohol?
No.
And have you understood what's going on in your case?
Yes.
And are you satisfied with your attorney?
Yes.
Has it been explained to you that if you decide to plead guilty, you would have to give up your right to a trial? You will not go back to a courtroom to face a judge or a jury, to confront your accuser, challenge the evidence brought against you by presenting your own defenses and arguments through counsel, and the state won't have to prove its burden of proving the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to simple battery family violence?
Yes.
Your sentence is going to be 12 months to serve 180 days, credit for time served 115 days. Your jail time for this case is over. However, you have quite a few matters holding you at the jail. Once these matters are resolved and you're released, you must report to Fulton County Probation within 48 hours of being released. On probation, you will complete a domestic violence intervention program, and you must enroll in that program within 30 days of being released and complete all 24 classes without missing or skipping them. Those classes will have to be paid out of your own pocket. At all times, you have to have no contact with Jemiah Colsey and no contact with any child or children that you share with her or the children that she has. Ms. Colsey will have to make alternative childcare arrangements, so you may return to your parents' home, but please advise your parents that she's not allowed to bring herself and the children to their home. Do you understand?
Yes.
If you wish to have any kind of joint custody or joint parenting with the child or children you share with her, you would need to file a legitimation case and obtain a court-ordered parenting plan. At all times, stay away. I'm assuming 653 Boulevard Northeast is not the parent's home. Is that correct?
No.
That's correct.
Okay, so stay away from 653 Boulevard in Northeast Atlanta.
Judge, I would ask, given that I'd outlined his situation, if you could waive the first 3 months of probation.
Waive first 2 months of probation.
Duly noted, Judge. Otherwise, also for the record and as a housekeeping matter, I discussed with my client the plea forms, and he's authorized me to sign off on his behalf and initial therein.
Noted. Thank you. All right. Thank you, Mr. Murphy. Thank you, South Annex.
Mr. I'll take a look at that thing. Thank you, Judge.
Thank you. Courtroom 2, who do we have, please? Oh, sorry, not courtroom 2, ACDC. And that was Mr. DeCesar.
That's correct, Judge. Mr. DeCesar is going to be entering a negotiated plea.
All right. Frank DeCesar's case is 25 CR 53578, accused of simple battery from September 5th, 2025. He also has a bench warrant from September 10th, 2025, case 26 FTA 062. Mr. DeCesar, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. Your counsel is Mr. Tom White. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Scirocco, what's the recommendation?
On the simple battery, Your Honor, the state's recommendation is 12 months, served 48 days, credit for time served, balance probated, MHET, social worker visit for housing or any other issues there. No further violent contact with James Smith or any of the hospital staff at the Emory Dialysis Center. Upon acceptance of the plea, the state has agreed to null pros position 16, which is the failure to appear. We have spoken with James Smith, stated to us that he's doing fine. He understands and agrees with the state's recommendation here. He did want to add an ADAT. He said when the defendant came in, he could not confirm whether this was an MH issue or a drug-related episode. So I would ask that Your Honor consider his recommendation there, but the state's recommendation is as was stated. If we could sound from Mr. Smith, and also if the defense would stipulate the factual basis, venue, and ID for purposes of the plea.
Mr. White, do you so stipulate?
We do stipulate for the purposes of the plea, Judge. We would ask that the plea is negotiated, and also ask if the case manager could give us his date of incarceration. So
I have 28 days in custody.
okay.
Okay. James Smith, or anyone from the Emory Dialysis Center, if you are present and like to be heard, this is the time to unmute and start your video. Right, Mr. DeCesar, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in your cases?
Yes, Your Honor. I do have a couple questions, but I'll hold them off until you say it's time for me to ask.
I'm sorry, you sound very muffled. I couldn't hear you.
I said no, Your Honor. I do have a couple questions, but I'll hold them off until you say it's time for me to ask.
Okay. Are you satisfied with your attorney?
Absolutely. He's super polite and he's great.
And you understand you'll be on probation to complete a MH evaluation and treatment. Did your attorney explain that to you?
He did. I don't know what MH stands for, but
Well, I didn't word it that way. It's mental health.
Okay.
Yeah.
Are you okay? What's your question?
As
Is
mentioned,
it about PAD?
it's about the housing, and then making it out to the mental health evaluations.
I see that he's residentially challenged. We can request a social worker to speak with you to assist you with housing and placement once you are released. Is that acceptable?
So that would, how does that work? They just show up at the jail?
Yes,
right after
before you're released.
Okay, thank you so much. Yes, Your Honor, that's super helpful. Thank you.
Were there any other questions?
No, ma'am.
Okay. As I was saying, you are satisfied with your attorney services. Has your attorney explained to you that if you decide to plead guilty to this charge, you would have to give up your right to a trial? You will not go back to a courtroom to have a trial in front of a judge or a jury. You will not get a chance to face those accusing you of this charge, to be able to present your own legal defenses and arguments, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Absolutely, Your Honor. And I'd like to apologize to the person that I did the battery on, and just say I'm really sorry. And to you, I'd like to say that it won't happen again.
Okay. How do you plead to one count of simple battery?
Guilty.
Your sentence is going to be 12 months to serve 48 days, credit for time served 28 days. The rest of the time you'll be on probation. You report to the Fulton County Probation on Tuesday before 3 p.m. While you're on probation, you will undertake a MH evaluation and submit to any treatment that's required. You're also to have no violent contact with James Smith or the hospital staff at the Emory Dialysis Center. So if you see Mr. Smith, you can apologize to him, but there cannot be any verbal or physical altercations at all. Understood?
Absolutely, Your Honor. Thank you.
All right. comply with all treatment and medication that you're prescribed. And before you are released, you will be seen by a social worker to assist you with housing and placement. Thank you.
Thank you so
Thank you,
much.
Good luck, man.
Judge, when you get a moment.
All right, courtroom 2, who do we have?
54 and 55, Mr. Taylor.
Okay. Mr. Taylor is represented by
Me, Your
Ms.
Honor.
Tucker, and that's going to be a plea. Okay, thank you. Jeremiah Taylor is accused of criminal trespass from May 4th of 2024, case number 25 CR 4118H. He has also a bench warrant from September 29th, 2025 under 26 FTA 065. Mr. Taylor, you've been advised of your rights and your attorney is going to be Ms. Tucker. Please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Mr. Scirocco?
Yes, Your Honor. On position 54, the criminal trespass, the state's recommendation is 12 months, served 38 days. Credit for time served, balance probated, BHET, stay away from 4300 Caveat Court, and that is in South Fulton, as well as 20 hours community service. Upon acceptance of the plea here, the state will null pros position 55, the FTA. We would not object to non-reporting upon completion of the conditions here, and if the defense would stipulate to factual basis, venue, and ID for purposes of the plea.
We do so stipulate for the purpose of the plea, Your Honor, and we will request non-reporting once he completes the eval and the community service.
Any objection?
No, Judge.
Right. His probation may be non-reporting once he has completed the evaluation and all necessary treatment. He completes the 20 hours of community service and he's up to date with his probation fees. And of course, if there are no probation violations. Mr. Taylor, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, I did.
And are you satisfied with your attorney?
Yes, I am.
If you decide to plead guilty, you would have to give up your right to a trial in front of a judge or a jury. You won't go back to a courtroom to face your accuser, challenge the evidence brought against you, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to criminal trespass at the Caveat Court in South Fulton?
Yes.
Your sentence is 12 months to serve 38 days. Credit for time served. I'm assuming it's 14 days or more. Jailings. Oh, he has
19 days.
I'm sorry, Ms. Tucker, what'd you say?
He has 19 days.
Yes, that would be correct. Yeah. So he has completed the jail time, so he will report to probation on Tuesday before 3 p.m. While he's on probation, he will undergo a BH evaluation and any treatment that's required. Stay away from 4300 Caveat Court while he's on probation, active or non-reporting. And also complete 20 hours of community service at a minimum rate of 5 hours per month. Once he has completed the evaluation, treatment, the community service, and he's up to date with probation fees, his probation may be non-reporting. Thank you.
Thank you.
All right, that's 3 through 6, Mr. Bradley.
Mr. Bradley has 2 cases and a bench warrant. The bench warrant is 26 FTA 058 from February 10th, 2025. His 2 other cases, position 3 is 24 CR 2402F, accused of simple battery, family violence, and criminal trespass from September 18th, 2023. And he has a willful obstruction of an officer from January 30th, 2024 under case 24 CR 2403F. Mr. Bradley is represented by counsel, Mr. Tom White, and this is going to be a plea. Please raise your right hand, sir. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speaker?
Yes, ma'am.
Thank you. Mr. Scaraca?
Yes, Your Honor. For position 3, counts 1 and 2. On the count 1, simple battery family violence, the state's recommendation is 12 months served 68 days, credit for time served, balance probated, undergoing complete FFIB, no further contact with Africa Mobley, stay away from 865 Fox Street in Atlanta. For count 2, the criminal trespass, 12 months probation concurrent with count 1, no further contact with Africa Mobley, stay away from 865 Fox Street in Atlanta, again, that same address. As for position 4, the willful obstruction, 12 months probation concurrent with position 3's case, $300 fine. Upon acceptance of the pleas here, the state will null pros the FTAs for position 5 and position 6. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea. If we could sound for Miss Africa Mobley at this time. Additionally, we would object to non-reporting here, given the history.
Mr. White?
Your Honor, we do stipulate for the purposes of the plea, we are asking to convert the $300 fine to 30 hours of community service. And we would ask that his probation go to non-reporting once he completes all of his requirements.
Mr. Bradley has significant charges holding him at the jail, and he was released from the willful obstruction on May 9th, 2024, and has incurred significantly more serious charges since that time.
And those are just
Until he was-
allegations at this point, Judge, so.
Understood, but they're still significant and numerous. His probation for non-reporting is denied. And of course, he won't be able to start probation until he's released from these holds. So I'm not sure when that's going to happen. In the meantime, the request to amend the $300 fine to 30 hours community service is granted. Given this information, Mr. Bradley, would you like to proceed with the plea offer?
Yes, I have.
Mr. Bradley, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your cases?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not be able to go back to a courtroom, face a judge or a jury, confront your accuser, have the ability to present your legal defenses and arguments through counsel, and the prosecutor won't have to carry its burden and prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to simple battery, family violence, and criminal trespass from September 18th, 2023?
Guilty.
How do you plead to willful obstruction of an officer from January 30th, 2024?
Guilty.
Sorry, repeat.
Guilty.
Your bench warrant on position 5 is going to be null prost. Your sentence for position 3, simple battery, family violence, is 12 months to serve 68 days. You'll be given credit for 44 days. 34 days. Once you are released from the Fulton County Jail and there are no holds, you shall report to Fulton County Probation to begin probation, and that report must be within 48 hours of being released. While on probation, you are to have no contact with Africa Mobley, stay away from 865 Fox Street in Atlanta, Georgia, and you are to enroll and complete a domestic violence intervention program. This must be done within 60 days of being released. This is a series of 24 weeks of classes that you must attend and complete. without missing or skipping any of the classes. For the criminal trespass is 12 months probation concurrent with count 1. Again, no contact with Ms. Mobley and stay away from the location. For position 4, the obstruction of an officer, your sentence is 12 months concurrent with position 3, and it will be an additional imposition of 30 hours of community service. You can do the community service at any nonprofit agency, but not a church and not a school, and you're to do it at a minimum rate of 5 hours per month. Thank you. Yes, Mr. Murphy, you want to ask something?
Yes, Judge, I'm going to be taking an appointment on position 32. That's Jamarcus Jackson. I've seen the state's recommendation. It's requiring additional time. So if we can reset that to Thursday as well, so I can see him and outline what they're offering.
All right. Mr. Jamarcus Jackson's case is going to be reset to January 22nd at 9 a.m.
If I could interrupt, Mr. Murphy, the state cannot advise as to the time he served, but you may want to check that one more time before we go ahead and reset this.
Okay, duly noted. Then I'll try to, if someone can put me in a breakout room with Mr. Jackson, I'll chat with him.
I don't know where is Mr. Jackson? Is he in courtroom 2? All right. Mr. Murphy, you'll have to call the jail, or the jail can call you.
If the jail can call me, I'll be ready. I'll jump off right now. Thank you.
All right. The gentleman who are seated, remain seated, please. Have a seat. Are you Mr. Jackson?
Oh, these are position 10.
10, okay.
Judge, Mr. Murphy can let him know that
main
Mr. Jackson's been in jail for 15 days as of today.
All right, thank you.
Thank you, Ms. Lewis. So I'll wait for, join the breakout room. Thank you.
No, call the jail, please, Mr. Murphy, or.
Yeah, they're going to.
We about to call Murphy now. We about to call Murphy now.
Excellent, thank you, sir.
In front of you, position 10.
Shemaine Coffey, Coffie, is accused of simple battery against an officer and willful obstruction of an officer. His case number is 25 CR 8242F. Incident date appears to be November 14th, 2025. Mr. Coffey, you've been advised of your rights, and your attorney is Mr. Tom White. May I place you under oath for the plea? Is this a plea, Mr. White? I'm sorry?
It is,
Okay.
Judge.
Mr. Coffey, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, Your Honor.
Thank you. Mr. Scirocco?
Thank you, Your Honor. The state's recommendation for Mr. Coffey on count 1, the simple battery against a law enforcement officer, is 12 months served, 120 days, credit for time served, balance probated, $500 fine, and an Op21 law and decision-making course. As for count 2, the willful obstruction of law enforcement officers, which, to clarify, it is a misdemeanor here. 12 months probation, that is to be served consecutively. To count 1, $300 fine. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Mr. White?
Your Honor, we do so stipulate for the purposes of the plea. We would ask that the $800 in fines be converted to 80 hours of community service. He's been in jail 90 days at this point and has no employment, so it'll take him a while to get back on his feet. And we'd ask for 3 months of fee waivers.
He's got 3 open probation cases. And now we're going to tack on a 4th one?
I do not know if I still currently have my job, or I they got my.
Judge, my information is that there is one case, probation case holding him. Are you saying?
I do have my.
I've got 25 CR 2800F, 25 CR 3216F, 25 CR 5826F. He's got 4 probation violation holds from December 23rd, 2025. is the felony obstruction has been reduced to a misdemeanor obstruction. That's what I've got, Mr. White.
Okay,
So, no, he will report every month.
I didn't ask for non-reporting, Judge.
No, I'm just saying.
Okay,
He will report every month. He will comply with all the other probation cases that he's got. I think he's got new charges, new probation violations.
Yeah,
And
here.
no, I will not convert the $800 fine to community service. This gentleman has a problem with complying with probation.
Maybe part of that is the amount of money that it costs and he doesn't have.
I woke up with a negative, I had money on my card, I found out what happened, and I had proof of the transaction.
Well, that is a significant problem. Would you like to take the case to trial?
Judge, we are entering a plea, and typically when a client can't afford to pay, they are allowed to work their fines off on community service just because he has
You're absolutely correct. But he has, in this particular case, he will have over a year and a half to get employment and pay that fine off.
I can pay.
So he's the.
I can't hear you, sir. What did you say?
I can pay y'all.
He can pay.
Okay.
All right. Mr. Kofi,
Yes,
have
ma'am.
you consumed any medicine or alcohol?
No, ma'am, no, ma'am, no, ma'am.
And have you understood what's going on in your cases?
Yes, they say, 12, could I repeat one more time, 12 months probation.
In this particular case, it would be 12 months less 120 to serve 120 days.
Yes. Do I have to report?
Credit for time served 63 days.
Okay.
There's also we asked for it to be served consecutively, Judge.
Oh, no, I know, that's count one.
Okay. All right.
And balance probated to pay a $500 fine due the Operation 21 program. And on count two, you will begin another set of 12 months of probation. That's consecutive.
Okay.
And that would require you to report to probation for an additional set of 12 months.
Okay.
And this will be an addition of a $300 fine,
Okay. Do I
in
need to
addition to the $500 fine from count one.
I understand, y'all. Do I need to report Tuesday to probation?
Yes, sir. Well, I think so, but you've got probation holds, so you report within 48 hours once your probation holds have been resolved.
48 hours, okay.
You do realize you have 3 other probation cases. I just rattled off those case numbers.
Okay, so I would be released.
Not according to this booking screen, unless probation's already been addressed. I don't know.
Yeah, I went to court yesterday, young. Judge McBurney.
New charge probations added for 25.
I was in jury court and they terminated, Judge McBurney terminated.
He's got a bond denied by Judge Locke, 25 PI. I'm just reading off the jailing screen, so.
And I will
Here
report-
are his probation violation case numbers, 25 PV 002628, 2629, 2630, and 2631. If you already, I don't know whether those been resolved. It doesn't say it's been resolved. If it's been resolved, then those orders need to be filed in order to close out these probation holds.
I understand, y'all.
So do you want to proceed with this plea, or do you want to wait till the probation?
Oh, I want to get this all resolved. I want to just go and get this over with. Yes, ma'am.
Okay.
We'll get this straight closed.
Again, have you understood what's going on in your cases?
So if I plead guilty to this, would I be violating my other probation? What you talking about?
I don't understand the question, sir.
Yes, potentially. We talked about this yesterday. Potentially, yes.
I haven't, no, if I plead guilty to these charges right here, would I be violating my other probations?
Potentially, yes. That's what I just said. We talked about this yesterday. And yes, a new conviction, it doesn't mean they'll use it against you, but they could.
We did talk to them, and she did not, he did not want me to serve it every time.
I'm going to reset this case
Ma'am,
to
ma'am.
January 22nd for Mr. Kofi to consider whether he
I
wants
want to play, I want to play out, I want to play out, Your Honor. I want to play, I would like to play right now. I want to play out. I want to don't get resolved. I want to play out right now. I want to separate the.
Have you understood now what's going on
Yes,
with
ma'am. Yes,
this
I do.
case?
Yes, I do. Yes, I do. Yes, I do.
Are you satisfied with your legal services?
Very satisfied, Your Honor.
And if you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not be able to go back to a courtroom to face a judge or a jury to
Yes, ma'am.
challenge the evidence brought against you, present your own arguments and defenses, and the state won't have to carry its burden and prove the charges beyond a reasonable doubt. Are
Yes,
you
ma'am.
prepared to give up these rights?
Yes, ma'am.
How do you plead to simple battery against a police officer and willful obstruction of an officer from November 14th, 2025?
Guilty.
Your sentence for count 1 is going to be 12 months to serve 120 days, credit for time served 63 days, balance probated. If your probation holds and any other matters have been resolved, you will then report to probation to start a new probation case. And in this particular new probation case, you will be required to pay a $500 fine and complete an Operation 21 law and decision-making course. For count 2, this will be a 12-month consecutive sentence to be served on probation. And while you continue to report to probation in person, you'll be required to pay a $300 fine. You will continue to report to probation in this particular case every month until the consecutive sentences are completed, and you'll be required to comply with all the other requirements in your other open probation cases.
Thank you. And
Thank you.
you have a blessed day, Your Honor.
Thank you.
Yes, ma'am.
Number 14, Ms. Davis.
Ashante Davis is accused of simple battery family violence from November 13th of last year, case number 26CR050F. Mr. Davis has been advised of his rights and his attorney is going to be Mr. White. Mr. White, how are we proceeding?
It's still
Okay.
plea, Judge.
All
Yes.
right. Raise your right hand, Mr. Davis. Do you solemnly swear and affirm the testimony you provide for this plea will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. Mr. Scaraco?
Yes, Your Honor. On the simple battery family violence, the state's recommendation is 12 months served 60 days, credit for time served, balance probated, alcohol drug evaluation, any recommended treatment, MHET as well, 80 hours community service, no further contact with Shante Ford, stay away from 574 Cedar Avenue Northwest, and I'll confirm the exact location of that. You would need a one-time visit for belongings, and his car would need to be taken away at the same time, so it doesn't have a reason to return there. Stay away from the children absent in order of the court. We are asking for continuous reporting probation for this case, given his prior conviction against Ms. Ford. We did speak with Ms. Ford. She states she understands and agrees with the plea offer. She said she did express concern with respect to the defendant having no place to go once released. So a social worker visit might be appropriate here as well to assist him with housing. If we could sound for Ms. Ford at this time, and we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Mr. White?
Your Honor, we do stipulate for the purposes of the plea. We just ask to accept the plea as negotiated. We would ask to waive 3 months of probation fees. And that's all, Judge.
Shante Ford, if you're on Zoom and want to address the court, please unmute and start the video. Right. FYI, Mr. Ashante Davis is still on active probation in case number 25 CR 006656F. Looks like he was sentenced on October 30th of 2025. And as far as I can tell, this one requires him to do ADT, MHET, and 80 hours community service, stay away, no contact. In his open probation case, same requirement. He's also, in addition to which, he's also required to do 12 weeks of anger management. Okay. Don't see. Okay. Mr. Davis, have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your case?
Yes.
Are you satisfied with your legal services?
Very satisfied, Your Honor.
And you do understand that this would be your second open probation case in which you'll be required to complete the conditions.
I don't understand what that means.
It means you have another probation case from later last year that you're still complying with that. That's what she's saying.
Yes.
Okay. And one of the requirements of this new probation is that you're to comply with the probation requirements in all open cases.
Yes.
Has it been explained to you that if you decide to plead guilty to this case, you will have to give up your right to a trial? You will not go back to a courtroom to face a judge or a jury, to be able to confront your accuser, have your attorney assist you to present your legal defenses and arguments, and the prosecutor won't have to carry its burden and prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to simple battery family violence from November 13th, 2025?
Guilty.
Your sentence for this second probation case is going to be 12 months to serve 60 days, credit for time served 14 days. You will have additional jail time to complete before you qualify for a release. Once you're released, you will then report to probation within 48 hours of being released. For this new probation case, you will report to probation every month until the remainder of the 12 months in this case is completed. I will waive your probation fees for this case only for the first 2 months. While you're on probation, you will undertake an alcohol and drug evaluation and submit to any treatment and counseling, and this evaluation must take place within 10 days of being released. You will also undertake an MH evaluation and submit to any treatment that's required, and this must be done within 60 days of being released. You will complete 80 hours of voluntary community service with any nonprofit agency. This is 80 hours, new hours, in addition to any hours that you were previously sentenced to. And you will do these 80 hours at a minimum rate of 10 hours per month with any nonprofit agency that's not a church and not a school. At all times, you are to stay 200 yards away from Shante Ford and not communicate with her in any way, form, or manner, including in person, phone, email, third parties, and even on social media. You are to stay away from 574 Cedar Avenue in Northwest Atlanta. You're allowed a one-time visit with a police officer escorting you to the location to retrieve your personal belongings and to retrieve your vehicle. If your personal belongings and or your vehicle are not there, you shall vacate the premises immediately. If you believe that your items or your vehicle are missing and they're not there, you'll be allowed to file a civil claim for loss of property, and this can be done after 12 months from today. At all times, you have to stay away from Miss Ford, and I guess stay away from the children that you have with Miss Ford. Do you share children?
No.
Okay, but you're required to stay away from her children as well. And as I've stated, you are to continue reporting every month. Another condition of this new case is that you are to comply with the probation requirements in any other outstanding probation case, which at the present time is under case number 25 CR 006656F. Thank you.
What are those conditions on the other case, Your Honor?
Check with your probation officer.
I believe that was
All right, we got number 22 to 25, Mr. Green.
Okay.
Green?
Yes. Is that your client, Mr. White?
It is, Judge. I'm actually addressing him. He was undecided, and I'm asking him how you
Oh, go ahead.
proceed. Mr. Green, did you want to accept the state's offer, or do you want to enter a not guilty plea?
I was trying to have a negotiating plea with the judge. I could.
I'm going to need a minute to speak with
All
him,
right.
Judge.
Definitely. Please, the courtroom 2 can either contact Mr. White, or Mr. White, you can contact courtroom 2.
I'll give them a
Murphy?
call.
Okay.
Judge, on position 32, when you reach us, that's going to be a plea this morning.
All right. This is Jamarcus Jackson. Are you Mr. Jackson?
Madam.
Was that a yes?
Yes, Your Honor.
Okay, thank you. Mr. Jackson's accused of simple battery from December 14th of last year, case 26 CR 016B. Mr. Jackson, you've been advised of your rights. Your attorney is Mr. Murphy. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Scarpa?
Thank you, Your Honor. On the simple battery, the state's recommendation is 12 months, served 30 days, credit for time served, balance probated, 12-week anger management, no further violent contact with LaShantria Jackson, as well as 30 hours community service. We would object to any non-reporting here. We did speak with Ms. Jackson. She stated that she understands and agrees with the state's recommendation. And we would ask that the defense stipulate the factual basis, venue, and ID for purposes of the plea. And if she is online and wishes to speak, we would sound for Ms. LaShantria Jackson.
Ms. LaShantria Jackson, if you want to unmute and start your video. Nope. All right. And Mr. Murphy, do you so stipulate, and does the client accept the terms?
We do so stipulate. We do accept the terms. Mr. Scirocco and Your Honor, my client wanted the court to consider a nolo plea. This was a misunderstanding with the sister. He's going to be residing with his grandmother, and my client is on parole for a completely different matter. And of course, he's worried that he would be potentially sanctioned for this. His parole does not run out until the end of July. And we'd ask the court to consider a nolo, so that may put him in a better light in the event that parole wants to sanction him at some point. We'd also ask the court to consider waiving the first 2 months of probation. My client did attend and graduate from Atlanta Tech. He has a forklift license, and he's trained in logistical management, but he's not sure how soon, when he returns to the employment agency, where he is on the list. So he's not really sure how soon they will bring him back on full time. So the court would consider the NOLO plea in, as well as waiving 2 months of supervision fees.
We would object to the NOLO, given his, I mean, even though he's fairly young, he has an extensive, impressive criminal history for his age. And I don't see a NOLO in the past 5 years, but that is a privilege, not a right. The states would object to that. And yeah, that is all.
Judge, I don't think we're reaching too far on this. Again, this is out of concern for a sanction with parole. And again, he has the ability to earn a living and come back into society and meet the terms of this probation. And we're certainly not looking at early termination of probation. We're just asking for to be put in a better light in the event that parole wants to do something to him.
May I have his GCIC, Ms. Talbot? This is position number 32.
It's a minute, Your Honor. What was his name? Let me look at the calendar. I'm sorry.
Jamarcus Antonio Jackson.
Okay, give me a minute because I didn't have his. Hold on just a moment.
He says,
So this is so let's make reference comment. Dealing danger about safety and the water side.
I can also provide it, Your Honor.
Ms. Talbot, if you don't have it yet, I'll have Mr. Scirocco read it out. Mr. Scirocco?
That's fine. I'm sorry. My computer's moving so slow.
That's okay. Go ahead, sir.
Yes, Your Honor. I see 21 cycles, including this. As far as convictions go, he has, it looks like at least around 10 dating back to 2014. But most recently, purchase, possession, manufacture, distribution, or sale of marijuana, receipt, possession, transport of firearm by a convicted felon or felony first offender, possession of a firearm during commission, and possession or use of drug-related objects. That was a 2022 conviction. Obstruction conviction. These are all convictions. 2021, purchase, possession, manufacture, distribution, sale of marijuana. 2 convictions, 2 separate cases from 2018. NOLO to criminal trespass in 2017. Simple assault and criminal trespass 2017. NOLO to pointing or aiming a gun or pistol at another 2017. Criminal trespass 2015. Disorderly conduct 2014. And I will say that as part of that, it looked like battery, family violence, and simple battery, family violence charges were null-prossed as part of the plea there. There are also more recent arrests with, again, the same marijuana charge listed earlier, as well as obstruction, possession and use of drug-related objects. Presumably that's open in DeKalb. It's a 2021 case. And reckless conduct, unauthorized discharge of firearms within 50 yards of a
That is
highway.
adequate. Thank you, Mr. Scirocco.
All right. Oh, sorry. Probation violations. I see 5, most recently in 2021.
Mr. Murphy, your client's run out of luck.
Duly noted, Judge. We had to ask him again. I feel that he's turned the page and he's on parole for the marijuana charge.
Understood.
Okay,
So,
Judge,
Mr. Jackson, you are free to challenge this charge in a court of law, and you may be acquitted or another plea offer may be on the table. But right now, given the circumstances, court's only going to accept a guilty plea, or if you want a not guilty plea, and we'll schedule it for trial. What would you like to do?
Your Honor, I've been doing everything that I can to stay out of jail. I work, I was constantly in school. I just recently received my custodial maintenance trade. Like my attorney said, it was just a misunderstanding. I woke up with a negative balance. I don't understand why money was taken out of my card without me knowing. I found out and got proof of these transactions. It wasn't them. It wasn't my sister or my mom that was taking the money. It was something else. I had got a new card and blocked that card out. We had an understanding and made an agreement. We both on good terms with me and my sister. We're fine. We don't have no problems with each other.
I wish she was here then. but she's not here.
And I reached out. I left a voicemail.
All right. I mean, I'll be glad to reset it to next Thursday if she shows up to consider it. I understand, sir, but Mr. Jackson, you've got significant history of what is most concerning firearm-related convictions in which you took advantage of a nolo contendere plea. And that's what I mean by your luck has now run out.
Mr. Jackson, do you want to go forward with the plea of guilty?
Yeah, I understand. No matter what I do down here, I'ma always lose. So I guess I'm gonna plead guilty, and then y'all just whatever goes on, goes on. It don't matter. It don't matter. I just want to handle this. I don't want to keep coming back and forth about something
Duly
very.
noted, Mr. Jackson. I understand. So then we're going to go forward with the plea today.
All right. And Mr. Jackson, have you consumed any medicine or alcohol recently?
No, ma'am. No, ma'am.
Have you understood what's going on in your case?
Yes.
And have you, are you satisfied with your attorney?
Yes.
If you decide to plead guilty to this charge, you would have to waive your right to a trial. You will
Yes.
not be able to go back to a courtroom to face a judge or a jury, to be able to present your own defenses and arguments. Just 1 second. Could somebody please remove Motorola from the Zoom?
Stupid as fuck. She petty as hell.
Ms. Champion, please remove this. Thank you. As I was saying, if you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not be able to confront your accuser, be able to present your own defenses and arguments, and the state won't have to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of simple battery from December 14th, 2025?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other holds, then you should be able to report to probation on Tuesday, and you will then complete 12 anger management classes, and they must begin those classes within 60 days of being released. At all times, you're to have no violent contact with LaShantria Jackson, and you're also to do 30 hours of community service with any nonprofit agency at a minimum rate of 5 hours per month. The community service can be with any nonprofit agency, but it cannot be a church and it cannot be a school. Thank you.
Judge, will you be willing to waive the first 2 months?
I will.
And Judge, the last thing is, as a housekeeping matter, I did advise my client, and he has authorized me to sign an initial therein on the police statements therein.
All right. Yes, please do. And please forward them to Ms. Lewis. Thank you.
Thank you. That's all I have, Judge.
Thank you, Mr. Murphy. Courtroom 2, do we have another case?
Yeah, ready?
We have 47 to 48, Mr. Rucker.
Mr. Rucker. Oh.
47 to 48.
Mr. DeMarcus Rucker is accused of reckless conduct from October 29th, 2025, case 25 CR 7153C. He has another case, 26 CR 047C, in which he's accused of criminal trespass and willful obstruction of a law enforcement officer from January 2nd of this year. Mr. Rucker, you've been advised of your rights, and your attorney is Ms. Tucker. Any priors? I mean, not priors. Ms. Tucker, how's your client proceeding?
So this will be a non-negotiated plea, Your Honor.
Okay. Mr. Rucker, please raise your right hand. Do you solemnly swear and affirm that the testimony you provide for purposes of this plea will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Mr. Scirocco, what is the state's recommendation for position 47 and 48, and briefly, just the factual basis?
Yes, Your Honor. For the state's recommendation for the reckless conduct position 47 is 12 months, serve 180 days, credit for time served. Balance probated, no further contact with Jeffrey Milligan, no further contact with Timothy Daniels. Stay away from 1334 Jonesboro Road in Atlanta, as well as no firearms and 80 hours community service. As for the criminal trespass and willful obstruction, position 48, on the trespass, count 1, 12 months probation consecutive with 25 CR 007153C. No further contact with Jeffrey Milligan or Timothy Daniels. Stay away from 1334 Jonesboro Road in Atlanta. No firearms. Again, count 2 would be 12 months probation. That is the obstruction. Concurrent with count 1, $300 fine. The first incident from October 29th of last year took place at the aforementioned address. Officers responded in reference to shots fired, and they were met by Mr. Milligan, who's the homeowner. He was in the process of obtaining an eviction for the defendant, who had not yet been served with that eviction. The resident, it's like a rooming house. There's a bunch of different individuals in the rooms there. There was an argument, dispute over lock changing. While the maintenance worker, Mr. Timothy Daniels, and Mr. Milligan were changing the locks, there was a verbal dispute, and the defendant proceeded to pull out a firearm and fire a shot within the residence. It ultimately deflected and hit a television within the residence, and a shell casing was recovered. Excuse me. He then fled outside the location, and this was confirmed with the other victim as well. There's multiple individuals within this residence. On the other case, that is the criminal trespass and obstruction, that was from January 2nd of this year at the same location where the officer was met by the caller. He explained that the defendant was inside the home, refusing to leave, so he returned back, and this was in, I'm sure, violation. I'll definitely be sure to verify, but I'm sure this was in violation of his bond for the aforementioned case. And he had been served an eviction notice, yet he had come back. He was given multiple verbal commands to exit the room, but he barricaded himself into a locked room where officers had to ultimately force entry to apprehend him. We did speak with Mr. Milligan, and I will say he does not agree with the plea offer. He thinks the offer is far too lenient to the defendant. He reiterates that the defendant had a gun and shot it near his foot. He believes the defendant intentionally shot near his foot, and when the defendant was released from jail, the first time he was told to stay away. That's what I will confirm here shortly. I'm sure that's the case. However, he came right back to the home, broke into one of the rooms, and according to Mr. Milligan, also stole jewelry and money from one of the female residents there and damaged all 6 bedroom doors. He believes more jail time is appropriate. And we've not been able to reach Mr. Daniels, but those are the facts there. With respect to his history, he does have convictions for aggravated assault and robbery. That was 2018. Receipt, possession, transport of a firearm by a convicted felon, 2015. And there's also a more recent battery arrest out of DeKalb that presumably opened, 2025 case. And outside of that, there is a possession of a Schedule I controlled substance charge. It says conditional discharge. I didn't see a final disposition, but that involved also carrying a weapon without a license and possession of firearm during commission, of which he was indicted, but I just don't see the disposition for it. But that was 2013. He also has probation violations from 2016 and 2 from 2014. as well as FTAs from 2015 to 2012. If we could sound for Mr. Milligan and Mr. Daniels at this time, and we would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea, Judge.
Jeffrey Milligan and Timothy Daniels, if you'd like to contribute, please unmute and start your video. All right, they're not there. Miss Tucker, all right, what is the defense position?
Your Honor, we're requesting, thank you, a time served offer here. He currently has credit for time served. It should be of 72 days. Mr. Rucker initially waived his appearance on the for the bond hearing that took place on November 7th. So he was not aware of all the terms of his bond. Once he was released, he wasn't given a copy of his bond order. He was in medical at the time, which is why he did not appear to court on that matter. I believe he said he's diabetic. He was receiving IV drips on that day, so he wasn't able to attend court. So he was never notified that he was ordered by the court to stay away from that address. And it was previously his legal residential address. He also was not served with the eviction. The eviction was filed on October 31st of 2025. The offense date is October 29th. So he was incarcerated when it was filed. He was not served by the Fulton County Marshals while he was incarcerated. So to his knowledge, once he was released from jail, he simply was just attempting to return home. And it was, late in the evening once he was released. So he was very confused with the situation. He maintains he would not have returned to the property had he been properly notified from the court or from the marshals that he was evicted from the property. So we're asking that the court takes into consideration the 72 days that he served on these two cases, and give time served. He was also enrolled in school at the time. He's now been unenrolled since he's been incarcerated for so long. His property, all of his belongings were at that property. He's now lost all of his property, so he will have to essentially completely reestablish himself once he's released. And it could have been prevented had he received proper notice from the court, his attorney, or the Fulton County Marshals. He just had no knowledge that he wasn't allowed.
Judge, your honor was the one who handled this case back on November 7th, 2025, and you were the one that ordered the stay away.
Yeah, I'm going to let you counter as soon as Ms. Tucker is done.
Oh, I'm
Thank
sorry.
you.
I didn't mean to
The
interrupt.
court did order to stay away, but my only statement on that was that he waived appearance. He did not hear the court's order in person, and he did not receive a copy of the bond order thereafter. So he had no personal knowledge that he was ordered to stay away. We do understand that your honor did order that bond, those bond conditions. He just had no knowledge. So at this time, we're just asking for time served on for the 72 days he's currently served.
All right, and Mr. Scirocco. Yes, sir.
Yes, Judge, I'm sure you made it abundantly clear that he was not to be anywhere near these individuals, nor back at the property with the C hearing back on November 7th of last year. And, the facts in and of themselves are especially concerning. We believe he poses a significant risk to anyone that lives in that home, especially Mr. Milligan. But beyond that, he shouldn't have had a firearm in the first place. And you have two people saying he fired a shot, even though he is a convicted felon with violent prior convictions a violent prior conviction, an open violent case, and also a previous felony firearms charge. So all this is incredibly concerning. And the state's offer in this case, its recommendation is more than reasonable for this case. And as you can hear from what our victim has stated, perhaps it may not be enough. So what we are recommending is that the court go with the state's recommendation. And that is all for the state.
Okay. The court will adjust the 12 months to serve 150 days. He will have a few more days at the Fulton County Jail, and instead to 150 days instead of to time served. And then he will be on probation, which will begin, I presume, late next week for 360 days. So for an additional 110 days for the position 47. And then, of course, he'll be on probation for an additional 12 months for position 48. Does your client understand that he'll be on probation for up to almost a year and a half?
Yes, Your Honor, I did explain that the second case, the probation would be consecutive.
Okay. And the other requirement is that he's required to stay 200 yards away. That's the length of 2 football fields from the location at 1334 Jonesboro Road in Atlanta, Georgia. He's not allowed to go back to that location. He's not allowed a one-time visit. He's not allowed to contact any of the individuals who own or reside at that property. Does he understand that?
Yes, Your Honor. Can I just have one moment?
Sure.
We're ready to proceed, Your Honor. I did have one additional request of the court. If count for position 48, count 2, if the $300 fine could be converted into 30 additional hours of community service.
Denied.
Okay, he will have to establish income. He will have to replace all of his possessions that were.
I will waive first 3 months of probation fees.
Thank you, Your Honor.
Anything else?
Nothing further.
None from the
And
state.
he understands that he's not allowed to consume any illegal drugs, and he's not allowed to own or possess any firearms. His right to own or possess a firearm is now suspended while he's on active probation.
Yes, Your Honor.
If he's in possession of a firearm, it will be considered a probation violation, and he'll be back in jail to serve out the rest of these 2 years. Does he understand that?
Yes, Your Honor.
I hear from you, Ms. Tucker. I don't hear from your client.
Yes, ma'am.
And can I reiterate that you are not allowed back at this location, 1334 Jonesboro Road in Atlanta, Georgia? Do you understand that?
Yes, ma'am. May I say something?
Only if your attorney wants to let you say it.
Okay. I'm not gonna say nothing out of hand. But
In front of the prosecutors, I just.
yes, but I promise you, if I had any knowledge to not go back to the residence, I never would have been there.
Mr. Rucker, your attorney has already argued that you didn't have personal knowledge, but you understand that in the eyes of the law, notice to your attorney is notice to you.
All right, now I do. Now I'm
Okay, but you are not allowed back to that property.
Yes, that's completely understood. And like I have lost a lot. Like I don't even want to try to go back and get my property, but everything
Not allowed.
Right, everything I've owned was in that house. I've lost everything. I was in college. I would have graduated 11 months in
If
advance.
I accept this plea, then I accept the fact that you discharged a firearm in a property with no evidence that anybody else was armed. If you want to pursue this line of narrative, I can decline the plea offer and have you scheduled for trial. And you can try to convince 6 to 12 people that you were absolutely in the right to discharge a firearm.
I'm fine with the way things are now.
I mean, it's up to you. I don't have to accept this plea offer. You decide whether you want to accept this plea offer or whether you want to take your chances up with the trial. All I have right now is a possible factual basis that's stipulated, and I have a warrant.
I accept.
What would you like to do?
I accept the plea.
Mr. Rucker, if you decide to accept this plea offer, okay, please understand that I need to make sure that it's being done freely, willingly, and voluntarily. And if there's even a whisper that you are anywhere near that location, I authorize probation to immediately revoke your probation, and you would need to serve out the rest of the 2 years in prison. I'm very serious about this. I don't play when firearms are involved.
Yes, ma'am.
Do you understand?
Yes, ma'am.
Have you consumed any medicine or alcohol recently?
Only medicine. I'm type 1 diabetic.
Okay. Have you understood what's going on in your cases?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to enter this plea, it must be done freely, willingly, and knowingly. In that regard, has your attorney explained to you that if you decide to plead guilty, you would have to give up your right to a trial? You will not go back to a courtroom to have a trial in front of a judge or a jury. You will not be able to confront your accusers, those pressing these charges against you. You will not be able to have your attorney help you to present your legal defenses, your arguments, and any evidence you may have to challenge the evidence brought against you. You will also not be able to require the prosecutor to carry his burden of proof and prove all these charges against you beyond a reasonable doubt. If you decide to waive all these rights, then and only then can I proceed with this plea offer. Are you prepared to give up these rights?
Yes.
How do you plead to reckless conduct involving a firearm on October 29th, 2025?
Yes.
How do you plead to criminal trespass and willful obstruction of an officer on January 2nd, 2026?
Yes.
On the reckless conduct, your sentence is going to be 12 months to serve 150 days. Credit for time served, 72 days. Balance will be probated. You will report, if you have no other holds, you will report to probation next Thursday before 3 p.m. As I've already indicated, you are to have no contact with Jeffrey Milligan, no contact with Timothy Daniels, and to stay 200 yards away from 1334 Jonesboro Road in Atlanta, Georgia. You're also required to complete 80 hours of voluntary community service with any nonprofit agency. It cannot be a church and it cannot be a school. At all times, you're not allowed to consume any illegal drugs, and you're not allowed to own or possess any firearms. If you own any firearms, they shall be surrendered to the police authorities immediately for destruction. For the criminal trespass, your sentence is going to be 12 months probation consecutive to position 47. Again, no contact with Jeffrey Milligan, no contact with Timothy Daniels, and to stay away from 1334 Jonesboro Road in Atlanta, Georgia. No firearms and no illegal drugs. For the willful obstruction of law enforcement officer is going to be 12 months probation, concurrent to count 1, with a $300 fine. You will have the rest of the 18 months to pay off the $300 fine. You will report to probation every month, and you will be up to date with your probation fees at all times. I will waive probation fees for the first 3 months. Well, January is almost halfway through. You will start paying probation fees from May 1st, 2026 onwards. So technically, it'll be a 4-month probation waiver. Any questions, Ms. Tucker?
No questions, Your Honor.
All right. Mr. Rucker, are you and I on the same page about your conditions?
Yes, ma'am.
Thank you. Next case, please.
21, Mr. Gonzalez Ramirez.
Yeah.
Judge, we're gonna need a breakout room to speak with him,
All
with
right.
the interpreter.
Ms. Chansey, you're going to
Yes.
go into a breakout room with Mr. Tom White. Okay, do we have another case in courtroom 2 right now? Actually, I'm going to take a 5-minute recess, so let's go ahead and put courtroom 2 in breakout as well. Thank you. It is 12:26. We will resume at 2027. So we'll resume at 12:32. Thank you. Miss Lewis, what was that about? I don't know. I couldn't keep up with these.
Yes, ma'am.
Who is this person who was?
She's the mother of Mr. Green, and I guess she's trying to make the court aware of his capacity of being an autism person, and she just kept going on in the waiting room. She changed her name to who she is, and she's sitting in the waiting room. So I let her know that we're not gonna let her in until her son case come up until you address this, till you tell us. So
Okay, thank you. Yeah, we can bring her back into the main session.
Okay.
And then we will resume when Mr. Green's case is called. Thank you.
okay, you're welcome. Ms. Green, to stay on mute and keep your camera off until the judge address you, and please refrain from chatting in the chat to the judge. We will address you shortly.
The courtroom, we don't need him for the judge, so we're just gonna waive it.
Okay.
Okay. Mr. White, we ready?
Your Honor, it's just gonna be a waiver.
Right. Ms. Chansey, if you please interpret. This is State versus Ulysses Gonzalez Ramirez.
Esta es la fiscalía, el estado de Georgia con el señor González, contra el señor González Ramírez.
He is charged with possession and use of drug-related object, criminal trespass, and obstruction of an officer.
Él tiene un cargo de tenencia de objetos relacionados con la droga, allanamiento de morada y obstrucción voluntaria a la autoridad.
He has a right to remain silent. Anything he says in open court, his statements can and will be used against him. He has a right to an attorney, and his counsel is Mr. Tom White.
Usted tiene el derecho de guardar silencio. Todo lo que diga en un tribunal público, sus declaraciones pueden y serán usadas en su contra. Usted tiene derecho a tener representación legal de un abogado y su abogado es el señor Tom White.
Mr. White has entered a not guilty plea on his behalf, and his case is going to be reset for a jail jury trial.
El señor White ha entrado una declaración de inocente de su parte y su caso va a ser transferido para un juicio de la cárcel.
That concludes this case. Thank you.
Esto concluye su caso. Gracias.
Thank you. Thank you, Ms. Chansey.
Yes.
Appreciate
You're
it.
welcome. Have a good day, Your Honor.
You too. Thank you.
Thank you.
All right. Let me just go over the calendar, and we will take the competency calendar very shortly. On the add-on case, the probation revocation case, Mr. Horse, that was a revocation of probation with credit for time served. And then we had an add-on calendar as well, I believe.
We did.
And yeah, that was Miss Burnett, and that was a plea on position 1 and a null pros on position 2.
Vice versa, Judge.
Oh, okay, vice versa, sorry. Well, a null pros on the FTA, correct?
Yeah,
Okay,
number
thank
1.
you.
Mhm.
All right. And then on the main SAP calendar, position 1, Ashley was a plea. Position 2, Bowdler, that is going to be
I have
a
waived.
waiver by Mr. Bartel. And that's going to be further notice for jail jury. Position 3 was a plea. Position 4, plea. Position 5, null pros. Position 6, Julius Bradley. And that's going to be,
It's a null pros, part of 3 through 6.
oh, 3 to 6, that was a null pros too? Okay.
Yes.
Position 7, Jasmine Brown was a plea. 8 and 9 waivers of arraignment and further notice for jail jury. Position 10 was a plea. 11 was a plea. 12, Coleman is a plea. 13, Derek Collier that's going to be,
The state reset.
all right.
January 22nd.
All right, reset January 22nd. 14, Ashante Davis, that was a plea. 15, DeCesar was a plea. 16 is null pros. 17, Fleetwood is a plea. 18, Dwight Foster.
Reset for
is-
SAP 2-3.
All right. Reset to February 3rd. The same for position 19, reset to February 3rd, 21 Gonzalez is a waiver of arraignment for the notice. 22 Zacharion Green, who represents him?
That was me, Judge. We're asking to reset that to the 26th.
That's
26th of January.
Yes.
so that would be a Tuesday, is that correct?
No, it would be 27th. That's on the 27th. It's January 27th, it's a Tuesday.
Okay, that works.
And do you want to address that to his mother who's been on the line at this time?
Miss Green, Londina Green, please unmute and start your video. Okay.
Here she comes now.
And that goes all the way through to position 25, and that's all going to be reset to January 27th. Position 20, Miss Green?
Yes, ma'am. I'm sorry about that.
Counsel for your son, Zacharion Green, has indicated that the case is going to be addressed on January 27th, 2026 at 9 a.m.
Yes, ma'am. Thank you.
Right.
So, then nothing changed for his case status for his bonds amount.
They're all the same.
Yes, ma'am.
All
Thank
right.
you.
Thank you. Position 26, Hammock, is a plea. 27 is null pros. 28 is a plea. That's Jeremy Harris. 29, Brent Humphreys.
He's been released, Judge. He's
Okay.
position 29, 30, and 31. He's been released.
Okay, thank you. Jackson, position 32 was a plea. 33, Johnson.
He also
and-
been released.
Oh, okay. 34, Antonio McGee, that is reset to January 22nd. Mr. Murphy will be representing him. 35, Tony McGlone, and that is a waiver by Miss Tucker. So that's going to be further notice for jail jury. And that would be for 35, 36, 37, and 38. Position 39, David Neem on 9. Has that been transferred to Superior Court?
It is not, Judge. I've sent follow-up on one of those was a more recent case that came to us, so it was a more recent transfer, but I've sent a follow-up on the outstanding one and that one jointly together.
All right.
But I've not heard back.
Mr. Bartel, I believe you filed a waiver of arraignment, so are we still proceeding with a jail jury? Was that you? I thought I saw David Nine Bartel.
Yeah, you did, Judge.
Okay.
Yes, Your Honor. I did review this. Would a waiver be necessary? Because if it's transferred to Superior Court, he'll be arraigned there. For what it's worth, I mean, he does have 3 convictions for this that I saw in Odyssey.
Paul, he's actually, I would go ahead and waive it. He's been reset.
Okay.
11/25, 12/4, 12/11, 12/18, and now this. It's getting
Do
kind
we
of
not? Do we know why it's been reset so many times?
Pending a transfer, but since the transfer is not coming through, if you want to arraign it, it will go on a trial track with misdemeanor court.
Okay, well, we'll waive arraignment then and plead not guilty. I have spoken to him regarding that. And it appears there are other things holding him in.
All right. David Nimes' cases will be further notice for jail jury. 41, Mia Oliver, that was a plea, and 42 was a null pros. 43, Darius Parks, 43 and 44 were pleas. 45 is not a case, it's just a duplicate.
A duplicate, yes.
Yeah. 46, Portier Hernandez is a plea. 47, Rucker, that was a plea. 48 was a plea. 49, Ricky Smith.
I have reset for SAP January 22nd. They're asking for 1 week out, pending transfer.
122 reset. Jamal Statham, position 50.
I
It's a
guess
state reset?
same scenario. We
Okay,
set 1 week out, January 22nd, pending, transfer.
okay.
And Judge, this is another one. It's already been reset twice. We addressed bond if there's no resolution by the next time we would.
We'll address bond on January 22nd, or if y'all want to file a waiver and the case will be further notice for trial. Of course, the case can be transferred to Superior Court anytime before trial begins. FYI, okay? So reset to January 22nd for possible transfer or a bond hearing or a waiver. Lots of things can happen. Stovall was a plea. 52, Jacob Stewart. And 53, that's reset to January 22nd. And then that's also for position 53, January 22nd. Jeremiah Taylor, position 54, was a plea. 55 is null pros. 56, Tennyson is released, as well as position 57, same person released. 58, Gregory Thomas was a plea. 59, Montavious Thomas. And looks like this is going to be reset to what date?
We
Is
have
it?
We would request a 1 week reset for that, Judge.
All right. Possible transfer to Superior Court. Excuse me. And that's the same for position 60. Reset to January 22nd. Sorry, 61, Velasquez was a plea. And I believe that concludes the SAP calendar.
We also have the DV counter with private attorney, Ms. Rockwell.
Oh my goodness, she's been here since 9 o'clock.
Her client's been on the line.
Okay, thank you.
Hey, Judge.
Good
Will y'all
morning, Ms.
comment?
Rockland. Yeah,
Good morning at 12:45.
well, it's morning somewhere, so
Right.
we go
You
with that.
know, I don't know why I'm on this calendar, but I have Aaron Fernander, and somebody told me to sign in. Is his bench warrant set aside? I went and signed to get it set aside.
Okay, we have State versus Aaron Fernandez. Mr. Fernandez is on Zoom. Mr.
It's
Fernandez?
actually Fernander, Judge. I'm sorry.
Oh,
Tammy.
Fernander, excuse me.
Yes, yeah.
All right. His case number is 25 CR 005746F. Mr. Fernanda is on Zoom and represented by counsel Ms. Renee Rockwell. Mr. Fernanda, also like to remind you that you have a right to remain silent. Anything that you choose to say during this virtual proceeding, your statements can and will be used against you. This case was accused on September 19th, 2025. He was accused of simple battery, family violence, terroristic threats and acts on June 10th, 2025. Pursuant to a first appearance, he was provided with a 2,000 signature bond through pretrial services level 1. He filed an address change on October 14th, 2025. And looks like notice was sent but returned to sender. Let me just confirm. The address change was to a 2442 Arno Drive in Atlanta, Georgia, 30318. There was a return to sender. It was 2442. Looks like it was spelled as AMO Drive, Atlanta, Georgia, 30318. He apparently failed to appear before Judge Richardson on November 24th, 2025, and this bench warrant was issued. Let me see. We still have a Ben Hill Court address. Is that now a new address, or what are we doing?
I might have put a new address on the bench warrant. Well, whatever I signed to try to get the bench warrant set aside. He, without sparing the court all the details, he was living in his father's house. His father passed and left everything to him. Easier said than done. His mother needed him out the house. the allegation was that that's the fast way to get somebody out of the house and have them not come back, is when there's a family violence. Anyway, so then he was a bit homeless. I will make sure, Judge, he doesn't miss any more. Did I not fill in a good address? Mr. Fernandez, is that going to be your best address? Is he still with us?
Yes, he is. He needs to unmute. Brace, okay. Okay, he was putting on his headphones. Redirect your question, Ms. Rockwell.
Mr. Fernandez, is that your best address? The latest address on the file is the Ben Hill address?
He needs to unmute.
Can you put your thumb up? Is that your good? There you are.
Yes,
Is that Ben Hill address your best address?
that's 2018 Ben Hill Court. Hold on.
I'll go, Judge, I'm at the courthouse. I'll go file another one if that's not it. Sir, we're having trouble hearing you. Can you just text me your best address? Jesus Christ.
Trying to get there. I can't.
Mr. Fernandez, please tell us your full current mailing address.
Oh, yes, 2018 Ben Hill Court.
Southwest Atlanta?
Yes.
What's the zip code?
Hold on. I'm not sure. Hold on. Give me 1 second.
And can you just clarify if it's a house or an apartment?
Yeah.
House.
Okay.
30331.
Okay. That's the address we have on file at the present time. Mr.
Perfect.
Scirocco, do you have any objection to a set aside?
I don't, Judge.
All right. Mr. Rockwell, please submit a proposed order setting aside the bench warrant and make sure that he shows up for Judge Richardson's next calendar. We don't have one scheduled right now, but Judge Richardson, case manager, should put it on the next calendar unless you want to prompt them.
Thank you, Judge. And shall I send that to Ms. Lewis and Mr. Scirocco?
Just to Miss Katrina Lewis. We'll file that with the court.
Thank you. Proposed bench warrant set aside.
Yes.
Thank you.
Mr. Fernandez, between now and until the order is filed, please be aware that there's still an outstanding bench warrant. Okay, thank you. Y'all are free to go.
Thank you, Judge. Have a
Thank you,
good
Ms.
weekend.
Rockwell.
Thank
You
you.
too.
Thank you. Thank you, Ms. Rockwell.
All right. Let's
Have
see
a good
now.
day.
Thank you. Mr. Bartel, do you have any matters that are subject to a plea from the 11 a.m. calendar?
Yes, Your Honor. I've just talked to Mr. Vanis, who is on that calendar with another MARTA case. Ms. Tucker, I believe Mr. Vanis is able to enter a plea. Could you let me know what the state's offer is? If you could just email that.
Yeah, I'll send you an email real quick.
Thank you. And Mr. King is here, but I'm not sure about him. I need to consult with Ms. Burgess.
All right. All right. If you want to consult with Mr. King, and then I'll wait for Ms. Tucker to send in the offer. Mr. Fernandez, you're free to go.
Your Honor, I think Ms. Burgess and I are in agreement that Mr. King is not going to be able to proceed. So it would just be Mr. Vanis.
Okay. Let me see now. Okay. Is Mr. Vanis ready to proceed?
Well, I'll check my email for Ms. Tucker's offer.
Oh, okay.
Yep, I'm sending it right now.
Okay, thank you.
All right, Ms. Greenhouse, please hold until we address this plea. Mr. Fernguest, I'm waiting for Miss McLeod. Oh, she's here. Okay. Ms. McLeod and Mr. Guest, we can only address this case once I stop the live stream and have a closed court. So please hold until I address this last plea with Mr. Vanis. Okay, thank you. We'll just be in a brief 5-minute recess or less once Mr. Bartel pops in. Thank you. Okay, Mr. Bartel, are we ready to proceed?
We are, Your Honor.
Jesse Banis, okay. This is State versus Jesse Banis, accused of criminal trespass from December 31st, 2025, case 26 CR 007E. Mr. Banis, you've been advised you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Paul Bartel. May I place you under oath for the plea? Raise your right hand, other right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, yes.
Thank you. Ms. Tucker, yes, what's the recommendation?
Yes, Judge. It's a plea to criminal trespass with the terms 12 months to serve 32 days, credit for time served 16 days, balance probated, to complete the mental health evaluation and any treatment, and to stay away from MARTA. I believe that's the right math, so the intention is time served.
All right, thank you. I appreciate it.
He has served 16 days. And we would ask the court to consider waiving the first 2 months of probation fees.
Granted. Mr. Vanis, have you consumed any medicine or alcohol recently?
Just a little bit, just a little bit.
Were you able to understand what's going on in your case and understand your attorney?
Yeah, I'm understanding well clear and understanding well logical sense about it. Yeah, I'm not messing around.
Okay. And are you satisfied with your attorney services?
Yes, yes, yes.
If you decide to plead guilty to the criminal trespass at MARTA property, you will not get the chance to have a trial in this case. You will not face your accuser, challenge the evidence brought against you, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
I'll plead the rights.
Are you prepared to give up the rights I just outlined?
I won't plead false on me.
You're giving up your right to a trial.
I'll say right for a trial.
I don't understand. I'm sorry. I'm trying to do this as simply as possible. Mr. Vanis,
Yes.
do you give up your rights to a trial in this case?
No.
So you want to go to a courtroom and challenge this charge?
No, man.
In order to plead guilty, you would have to give up your right to a trial.
All right.
What would you like to do? A trial, or are you trying to enter a guilty plea?
Trial.
All right.
I think we probably need to ask for a reset on this case, Your Honor.
Case is reset to January 22nd, pending a possible plea or a waiver. Thank you.
Okay, thank you, Judge.
Am I getting out today?
Well, I'll talk to you.
Deputy, there's another individual in the courtroom. Are we going to be addressing him as well?
No, ma'am.
No, Your Honor. Mr. King's ready to go up too.
Okay. So, Ms. Greenhouse, thank you so much. That concludes the pleas for today.
Okay, thank you
Miss,
so much.
thank you. Miss